Not tomorrow, no, may not be possible. We'll see. How can we adjust?
Pardon, my lord. This case pertains to the Balesus extent as part of the proceeding, wherein the Hon'Ble Court directed the petition not to appeal before the lower court until further orders. The order was passed in the year 2006. Now the petitioner has received summons to appear before the Bologna trial court. And the Bologna trial court, we have appeared and took time and the
Summons issue.
we have issued
Here, what is the problem?
no issue if we have to appear then we have to issue bail because the case has now been committed to the special court.
These are the lawyers. What do you say, bar? What do you say, bar? What do you say? Something related to bar.
No, my lord.
Then
The Balesus scandal case. It's a hypothetical the year 2006. We were directed not to appeal.
when is the date fixed?
Next to 2024.
When the summon you receive?
No, we received the summon on 26, 2024. We appeared on that day through the council.
June you have.
Yes, okay.
Issued in June, you are in October. What is the urgency overnight?
The urgency that 24/10/2024 is the next day.
Is it by him not moves in between? Anyway, you give it, we'll see. How can we adjust it? We'll see. How can we adjust it? Yes.
It's a first criminal revision matter.
Sorry, madam?
Criminal revision matter. First criminal.
Last case. Last.
Vigilance.
Another matter.
Give you memo, you will.
And the question, madam, for the informant was appeared, but the petitioner is not appearing and enjoying the stay order as you also observed on the last occasion.
This is happening, what to do? That is the reason I am reluctant to give stay. Better that to finish the matter. That's the better idea.
And I think so.
Give the memo. Yes.
Pardon to me.
Yes.
Item 54 of the list, though it is in order, I file a memo for no instruction.
Oh, withdraw. 54. Yes.
Your Lordship, may I mention the matter?
Yes.
Lordship, item 82 is today's list.
Yes.
I am praying for an adjournment, Your Lordship. I am for the petitioner, Your Lordship. I have already informed the opposite party.
I will oppose that, my lord. It's a dead, my lord.
Yes.
Your Lordship, can it be posted on 22nd?
I can't be sure about the dates. See, how can we?
From 84 LRC, 3 conductor matters there, 2 in board and another is 3700 24 LRC. The matter has been settled LRC. The part payment already made in view of the mediation order LRC. Pre-LRC, application in 2 LRC. 3700 Sir LLC.
Yes.
I am to the fix of the date, my lord.
Your date fixed. You will
Item 80.
That has been settled, my lord.
Item 85. 85. My lord, friend is there.
85.
We are supposed to file the counter. Let it come after vacation.
After it is an entry for the continue, 84.
90 also.
90 also.
90.
90.
Let's say item 19, let's say, withdrawal memo has been filed, let's say. Can we allow them move after charge service?
I didn't follow you.
Has already filed.
File a withdrawal memo, let's say. Can we allow them move after charge service?
Memo after?
Move after charge service.
You have withdraw. Liberty is always there.
Item 19.
Liberty is always there. You will not ask for liberty. Yes. Mentioning. Yes. Entry order is there. Entry order is there. Continue. Yes.
19th also entry order is there. Let it be.
Yes. Start. Any mentioning? Online meeting?
Item 1.
Yes.
Taking an adjournment on behalf of Mr. Doctor. I'm taking an adjournment.
First item adjournment. The monetary order. No, it's not there. Okay.
Arrangement has been made.
Huh?
Interim arrangement.
No, interim arrangement was there earlier. Thereafter, the matter is simply adjourned on 29/8/2024, no order. Thereafter, on 11/9/2024. So therefore, there was no order. Only for one occasion it was made. Simply adjourned. On request, issued on December.
Item 2.
No entry more. Huh? Yes.
Lord, I do not know on behalf of my lord, praying for an adjournment, my lord. This is out of station trial, my lord.
Cows, my lord, sees my lord carrying the cows, and he has to pay my lord the rupees to the 4 lakhs to the Gosala, my lord.
Yeah, adjournment next week or after that?
Not next week. Last time also nobody appeared.
No, my lord. We have better pass.
This is none appears.
My lord. Praying for adjournment.
Immediately after this.
Item 3.
Obligation, my lord.
May I please go?
Yes.
It is purely a business transaction, but come on. Private matter. It is purely a business transaction between the parties, my lord.
Yes.
And during their business, my lord, some dispute arises for which the filed one case in Malgodam PS 207, that is under Annex 2 series, page 14.
This is 138 case.
No. I'm just coming, my lord.
Yes.
My lord, page 14, Lordship, may kindly pay.
14.
Yes, 14.
My cognizance is taken for 130.
Yes, yes. Yes, madam. Yes, madam. Coming to that.
Yes.
Annex 2 series, madam.
Yes.
In the year 2021, on 29/2021, a case was instituted under section 420, 294, and 506 against me
Yes.
by the same self-complainant,
Yes.
alleging the same occurrence what has been described in the complaint petition under 138 NI Act.
Yes.
Well, after the inquiry, the charge sheet was submitted and the cognizance was taken.
Under 420.
420, 506 and other offences. Now, after that, my lord, the again filed a 1CC case in the year 2022, alleging the same set of facts and same set of allegations.
420 and 138 doesn't go together. 420 and 138 go together.
Yes, they go together. But, my lord, taking the cognizance for the second time is under the law, my lord.
You are absolutely wrong. Absolutely wrong.
My lord,
Taking the cognizance order which you are challenging, it is only taking cognizance under section 138. This is an independent offense altogether.
yes, my lord.
Earlier this was 420, only the facts are same.
Yes.
But independent order section is accrued in favor of the complainant. We have to check this journal.
My lord,
What manner you have taken the check for that 420?
the 420 case was instituted
Maybe.
prior to 138 and it is squarely with the Hon'Ble case, my lord.
You argue all this. Right. Let the counsel for the petitioner seeks to withdraw the present
Lordship, the
petition.
tribute after vacation I will spare.
There is nothing. I should have imposed little cost on you. Because give it to something else to bar. To urge all the points before the court below at the appropriate stage with this liberty, the petitioner is disposed of here.
Item 4.
See, both the things are two different things, two different offences. 130, trial court has rightly taken 138. You have a difference, so that may be your difference in 130. But therefore, I have given that. Yes. Yes. Next.
4.
Oh.
May I please, Your Lordship? In the present case, Your Lordship, the petition challenges the very initiation of the criminal proceeding
Yes.
under section 13(2), read with 13(1)(b) of PC Act.
Yes.
So also 419, 420, 467, 468, 471, and 120B.
Tell me the ground why you are
Your Lordship, the sole ground is delayed in the process of investigation. Even after a whole day.
2013 is the FIR. Okay. And the charge sheet is now filed.
Constable has not given the correct certificate. And the petitioner was there. And all the petitioner, all the accused persons, there are a number of petitioner, the bank manager, he has granted loan in favor of non-existent persons or non-eligible.
Oh, not on merit. What she says is 2013 the FIR.
Because of
And you are not the
perhaps the delay is attributed to accused persons.
you have to tell me.
And that is where upcoming day, when I was conducting the case, in number of cases there in CRMC and open the stay order in other cases. You
Then, and you have given how many cases you have filed earlier?
Lordship, this is a only present case.
No,
A lordship, 2024, Your Lordship.
yeah, I'll give you that. 2013 is the FIR. If you don't allow the investigating agency to proceed with the investigation, the delay might have been caused. I don't know. So therefore, let us understand.
Your Lordship, we have been cooperating with the trial.
I don't know. Delay is attributable to you, you don't have a case. If delay is not attributable to you, you have a case. Okay.
He remain as a house under for a long time. I will reply. And share names, Your Lordship can decide your share names. 26654
You find everything.
If on that count, it will also be.
Verify करूँ तो अच्छी
And give a copy and
ना अच्छी वाली
Last of the question, Lordship directed to obtain the
My lord, extra, sir. They have, my lord. Oh, my lord, 307 is there, my lord.
the lady came.
Left, ready, came. All of them.
She was crying.
Injured also present, my lord, today.
Now what happened?
My lord, I have stated that the matter will compromise.
Why that day she was saying that the
Seeing his son, my lord, the son was injured after it, the VC, my lord.
but the victim was terribly
Here, my lord.
is there?
Victim statement.
Okay. You are in custody since you told me.
1, 2, 1, half February 2024.
That's it, sir. Thank you. Custody?
1, 2, 2024.
1, 2, 24. 24. Okay. Yes.
Page 20, the victim statement.
Offenses?
376 laws.
376. Okay. You are 20 years. What is the age of the girl?
17 years plus, 17 plus.
Just see.
My lord, CD has not come, my lord, but I can find out the person copy, my lord, of the victim, my lord.
Yes.
Out of love, I played away with the accused.
Page, my lord, annex of court.
164. Straight
My
line.
lord.
No, different, my lord, evidence.
The person where is that?
Page 20, my lord.
Page 20. Yes.
The offense took place also. Out of love, I played away with the accused Rumbuti.
First we went to Sambalpur, stayed there, so and so. They were relations. Right.
70 years.
Petition rejection.
But one mention, my lord, relying the evidence of the.
That time, during investigation, the statement of the victim was stated to be 17 years.
7 plus.
Recorded.
17 years.
164 years. The victim has also been examined as a PW1. PW1. Seeing in her examination chief has stated as under para 1. Sorry, para 2. Para 2, it is annexure 4. Annexure 4, para 2. The present petitioner is in custody since 1/2/2024. And the petitioner is 20 years of age. 20 years of age. Granted. Yes.
Item 8.
May I please, my lord? My lord, this is a case under section 20B2C. My lord, this is successive bail application of the petitioners.
CD is required 140 kg and 750
Call for CD. I'm calling for CD. Okay. Call for CD.
Yes.
And I.
May I please, Your Lordship? My lord, the petitioner is in custody since 6/12/2023. 6/12/2023. And charge sheet has been submitted, my lord, on 2/3/2024. Earlier, the petitioner had approached your Lordship. Your Lordship directed to renew his prayer before the land and court below.
Yes, after
Because charge sheet, my lord. It was again rejected and I have renewed my prayer.
What offenses?
My lord, offenses 302, 364, 120B by 34 IPC. But the man accused is Mahendra Bhavasagar, who was stated to have assaulted the deceased, my lord. And on the basis of the statement of the man accused Mahendra Bhavasagar, the present petitioner has been implicated, my lord. Otherwise, no.
Yes, yes, ma'am.
2/164 statement, my lord. That is with me, my lord.
Have you stated?
Bail application pending before the Supreme Court, my lord.
No. Mahendra is never approached.
No. One of the co-accused, my lord, approached this on court, my lord.
Suryam.
His prayer for his application is pending.
No. This is
Another accused also,
that was that in that bill application, your lordship was yesterday pleased to direct to remove the prayer. Nothing is pending.
Two 160%.
164, you say, you tell me about, say, Suryam.
My lord, Suryam.
Yes.
One my lord, Sadei,
Sunday?
Sadei.
Sunday.
ସବୁବେଳେ 29/11/2023 ଦେଖ ମୋର ସ୍ୱାମୀ ଛେଳି ଚରେଇକି ଘରକୁ ଆସିଲା ସନ୍ଧ୍ୟା 7টাରେ ଦାଣ୍ଡ ଆଡେ ଗଲେ ବାହାରେ ମହେନ୍ଦ୍ର ଭବସାଗର ଅଶୋକ କର ପ୍ରମୋଦ ଭବସାଗର ଶୁଭମ ଭବସାଗର ସୂର୍ଯ୍ୟମ ଭବସାଗର ସଜିତ ଜଗଦାଲ ଗୋଟେ କାରରେ ଆସିଲେ ଆମ ଗାଁର ଶୁଭମ ଭବସାଗର ବାପା
Yes, he has taken the name. Next, another.
Taken them on this next day, my lord, dead body.
Next.
One another, my lord. Southern Kor. Southern Kor. KNH. Mahendra Bhavsagar, Gulu among another extrajudicial compensation before this, my lord, witness. Riko among Mahendra Bhavsagar, alias Gulu among another Motadeki. କହିଲା ଯେ ସେ ଆଲୋକ କର ସେ କର ପ୍ରମୋଦ ଭବସାଗର ଶୁଭମ ଭବସାଗର ସୂର୍ଯ୍ୟ ଭବସାଗର ପିଟିସନର ଓ ସଞ୍ଜୀବ ଜଗଦାଲ ସହ ମିଶି ଆମେ ଗାଁର ମଧୁ କରକୁ ମିଶିଛି ଆମ ଗାଁ ମୁଣ୍ଡରେ ବରଗଛ ଠାରୁ କାରରେ ଅପହରଣ କରି ନେଇ ତାକୁ ଡିମିଙ୍ଗା ପଦରେ ଥିବା ରାସ୍ତା କଡ଼ରେ ମାରି ଦେଇଛନ୍ତି।
Let this.
Can say two witnesses will examine what witness to 27 will
What about these two? 164 statement. They have to.
Extrajudicial confession is by Mahendra Bhavsagar, the man accused, my lord.
Maybe 10-month murder case 302.
This taken because this two witnesses, my lord, not the council case.
The petitioner is accusing so-and-so. Allegation against the petitioner so-and-so. During the investigation, the statement of two witnesses, namely Sadai and Southern Court. Sadai and Southern Court was recorded under section 164 CRPC. They made a specific allegation against the present petitioner along with the other persons. Regard being head to the same, I am not going to rely the petitioner on the bail and mistake, however, liberty granted to the petitioner to remove the bail after these two witnesses, after the aforementioned two witnesses are examined. Trial court is directed to do well to see that these two witnesses are preferably examined over all other witnesses. With this observation, the petition is disposed of. Yes, next.
Yes, may I please? Yes, sir. Petitioner is custody principal 1/7/2023. This is the 1/7/2023.
1/7/23. Okay.
So second time approach this honorable court. Earlier appeal lawsuit directed to move after submission is charge.
Yes.
Now the offence under section 364, 302, 201, 120B, 34 IPC lawsuit.
CD not the
Yes.
CD and PM.
Yes, next.
The material lawsuit in bail fellow 985 lawsuit that was disposed of on 23/2024 lawsuit. So
Okay, let him go. Look at it. Yes, next.
Level was similar to that item 6 my lord, and this item 10 my lord. All are possible.
Huh?
6 was possible.
6.
Item 6,
302.
11.
Both cases 302. Case there is.
Case diary. Okay. Yes.
May I pray before the
Case diary. Huh? No, after this is an impractical thing.
No, why I am saying so? The CD is available. That's why.
Let him get it. Immediately after the immediately. First week. Yes.
6 and 6 also passed.
6 also, huh? Pass over, yeah. 6, 11 and 10. Yes. 12.
12.
has taken consent from his law. Nobody had appeared on behalf of the petitioners. So, lordships may kindly.
Elder and counsel for the petitioner submits that he has no instruction in this matter.
He has taken consent.
He has taken, the petitioner has taken consent from him. Hence, he is withdrawing himself from this case. non-APS on behalf of the petitioner. Hence the petition is dismissed.
30.
What is the offense?
Otherwise,
Offense is 302. Otherwise, yes, yes. He may engage.
Nay, with liberty to remove the bail plea before the trial court. Let it.
Item 30.
Yes.
Our offense under section 302 by 34 IPC, my lord.
Yes.
And the petition is in custody since 11/12/2023, my lord.
Visceral report has come?
My lord.
Yes. Custody since?
Since 11/12/2023, my lord.
11/12/22.
23, my lord.
23. Okay. Yes.
Register, my lord.
Hmm.
Ethyl alcohol, methyl alcohol, barbiturates, and a Vendacin group drugs in insecticidal.
Charged were filed.
My lord, that is when case has already been committed, my lord.
Poison, my lord, poison could not be detected in the viscera of the disease described above.
Yes.
No poison, my lord.
No poison was. And what, when the charge sheet filed?
Charge sheet file, my lord. I think, my lord, the charge sheet file, 5/4/2024, my lord.
5/4?
9/2, after 2 months.
No, you tell me what is the charges?
Charges 302.
302.
302 by 34 IPC.
Something charge sheet.
Then you write down. Petition rejected by the order dated 19/2/2024, whereby his bail plea has been rejected. And subsequent thereto, charge sheet has been filed on 5/4/2024. 5/4/2024. And the charges have also been framed.
No, my charge has not framed. Only case has been committed to the court of
commitment proceeding has already taken place. In view of the changing circumstances, petitioner may renew the bail plea if
then I will come.
trial court. If such bail plea is due, same shall be considered on the basis of the material and form part of the charge sheet next year.
Item 14.
Yes.
Here, let's see, petition in custody since 28th of May 2023, let's see.
Yes.
Allegation is that the charge sheet is submitted and the charge sheet offense is 302, 323 and 449 of IPC.
Yes.
And the charge sheet allegation is that this petitioner was in the disease and for some reasons when the parents of the disease was not happy with the relationship, so they disconnected the connection with the disease. And it is also alleged that being agreed on the interaction of the actions of the parents of the deceased, this person has forcibly entered to the house of the deceased while she was engaged in mobile, and she bolted the door inside and
His husband.
No,
not him. He was a lover.
Yes.
But the cause of death is due to shock and hemorrhage, my lord. And one statement, Jolly Sahu, the eyewitness was present, my lord. Jolly Sahu. Jolly Sahu, ସମୟ ରଞ୍ଜନ ବେହେରା ପିଟିସନର ରେଲିଭେଣ୍ଟ ପ୍ରଶ୍ନ ପଡୁଛି। ସମୟ ରଞ୍ଜନ ବେହେରା ଗୋଟିଏ ମୋଟରସାଇକେଲ ଆସି ମୋଟରସାଇକେଲଟିକୁ ଘର ବାହାରେ ରଖି ଘର ଭିତରକୁ ପଶିଲା। ମୁଁ ତାକୁ କାହିଁକି ଘର ଭିତରେ ଆସୁଛି ବୋଲି ଅଟକାରୁ ସେ ମତେ ଧକ୍କା ଦେଇ ମୋ ଝିଅ ଖୁସି ଡିସିଜ୍ ଥିବା ରୁମ୍ ପଶିଗଲା। ମୋ ଝିଅ ଜୋରରେ ଚିତ୍କାର କରିବାରୁ ଶୁଣି ମୁଁ ଘର ଭିତରକୁ ପଶିଯିବାକୁ ରଞ୍ଜନ ବେହେରା ପୁଣି ମତେ ଧକ୍କା ଦେଇ ବାହାର ପଟୁ କବାଟ ଦେଇ ପଳାଇଗଲା। ମୁଁ ଝିଅ ଥିବା ରୁମ୍ ଭିତରକୁ ପଶି ଦେଖିଲି ମୋ ଝିଅର ତଣ୍ଟି କଟା ହୋଇଛି ଏବଂ ଅଚେତ ଅବସ୍ଥାରେ ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ତଳେ ପଡିଛି। Another child is not there, my lord. The brother of the deceased, my lord.
After examination, material sample is full.
50.
Petitioner is the husband alone. Custody in support in 223 last one lawsuit quoted for today matter after calculating is 1 year custody period matter. And last one lawsuit quoted for 2 days after calculating 1 year custody period.
No, that is not right.
Yes, my lord. That's it.
What is the custody period?
Custody 4/10/2023 matter.
Coincidentally, it is fixed to 4.
No, my lord. That
Generally I do. Generally I say that 1 year and 3 months.
access submitted on session 498/306. 304.
306.
Yes, ma'am.
Yes, 306, but he is the principal accused. Allegation is under the influence of liquor, he was subject, the victim was subjected to torture for 2 lakhs demand. Immediately, just 2 years of marriage, she committed suicide. Even it was the allegation of the prosecution that they committed murder. But the sheet submitted under 306 was subject to approval. But the principal accused, my friend, is appearing for the parents. They are here in absconding.
No, my lord.
My only concern, there cannot be a fair trial once he is released.
But they have granted.
Tell me what condition you need.
Let him ensure the fair trial, early trial, my lord. The parents will never come. Their anticipatory bail has been refused.
No, my
Now it is
lord.
Other party does the matrimonial discord and if he has participated in the 306 or 302 is not there. And how she died?
That's a place, my lord.
Hanging.
The dead body is found in the parent
Hanging, my lord.
if it is hanging, how
I placed the receipt.
It's not 302 now. What?
No, it is not 302 now.
That's the problem. Two court action is there. You tell me what are the conditions you want.
Any condition, my lord, he is basically a seasoned criminal lawyer.
No.
Let him ensure the court, let there be a fair.
Sir, you give it writing.
I leave it to you. I was not so. My only concern, there should be a fair trial and early disposal.
Now, what I generally do is, if one violation, the concession is recalled.
Yes, sir.
Single violation.
Single violation.
And the concession will recalled by the trial court itself. That is the
Each and every day, you are watching the condition, other conditions.
right of petitioner and accused also elevated petition so far as co-accused those who are the mother and father of the present petitioner are concerned. They have been they have approached this court by filing ABA appeal number 2011 of 2024 by the order dated 1/10/2024. Interim protection has been granted to
Health condition.
the petitioner is in custody since 4/10/2020. Objection liquidative, the prayer on the ground that the releasing of the present petitioner may impact the free and fair trial, and it may be prolonged as well. Therefore, he submits that appropriate conditions should be imposed against the petitioner so as to ensure that the trial is proceeded at its pace, and no impediment is created by the petitioner at any stage. Regarding to the period of custody and nature of acquisition, granted with and all these conditions. Okay. And child single violation of the condition imposed by this court as well as by the trial court shall entail the petitioner the cancellation of bail granted by the.
IO is not submitting charge sheet because of pendence of these bail applications. It is for the prosecution to conclude the investigation. 1 year already almost elapsed.
Mr. Mishra is also.
No, that was not on the charge sheet was not.
I understand because the co-accused persons were not cooperating. Now they have got this protection. Mr. Rahul and counsel for the state submits that charge sheet could not be filed in the present case due to non-cooperation by the co-accused persons. Since now the co-accused persons have already been protected by this court in their anticipatory bail prayer, there is no impediment for the police to file the charge sheet.
Yes,
Charge sheet.
Yes,
Hence, the investigations shall be expedited and charge sheet must be filed.
My lord, in last division, lordship has obtained the health condition of the petitioner's mother, my lord. I have submitted before your lordship.
Health condition.
Well, For internal.
I have to one or two submit that the mother of the petitioner found so ill and she is continuing. Is ill.
Your lordship can have a glance the next prescription.
Into hell in what kind of illness?
Let us, my lord, your lordship.
What is the offense?
302, my lord. And in between, my lord, that out of 22 substituted witness, 11 numbers prosecution witness has already been examined.
What what I'll do is, listen, what I'll do is, I'll week 1 month interim rule. And I'll give you liberty to surrender before the court on a particular day and renew your bail plea there.
Yes, ma'am.
Regular bail plea there.
Yes, ma'am.
Okay. If you don't surrender, then both the things will go.
It is better.
Okay.
Right.
Petitioner is accused in so choking. Allegation against the petitioner. The petitioner is in custody since
14/5/2020.
14/5/2020. 20.
Well,
2020. In the meanwhile, how many witnesses have been examined?
11 witnesses.
In the meanwhile,
Out of 22.
out of 22 witnesses, 11 witnesses have been examined. His bail plea is pending before this court since 15/3/2024. 24. In the meantime, the petitioner has moved an interim bail application on the ground that the ground that his mother is terribly ill. A report was sought from the IIC BNpur police station regarding for verification of the health condition to the mother of the petitioner. The IIC BNpur police station by report dated 3/9/2020 has stated again regarding head to the aforementioned health condition of the mother of the petitioner. I am inclined to enlarge the petitioner on interim bail for a period of 1 month. No, for a period of 1 month. You are not seeing the prescription. Pentagal. You are not entitled, but since you are there for such a long time, you go for 1 month. You may be enlarged on regular bail if you surrender. 1 month. The petitioner shall be released on by the court in session with the appropriate conditions on. Next person.
1 month is count from the date of release.
Yes, the petitioner shall appear before the court on or before today immediately after completion of 1 month from the date of the release before the trial court. So, okay. Insofar as the regular bail play is concerned, I am not inclined to admit the petitioner on bail. However, since 11 witnesses have already been examined, liberty is granted to the petitioner to renew the bail plea before the trial court after surrendering before the court on completion of the interim bail period. If such bail application is moved, the same shall be considered on the basis of material available. Yes.
Item 17.
My lord, this is a matter of 376D, my lord. And unfortunately, CD has come, but unfortunately, the wrong CD. Due to the number.
CD
Yes, my lord.
Withdraw the case, my lord. Withdraw this case, my lord.
Obviously, let us know the petitioner seeks to withdraw the present case to remove the bail plea before the trial. Okay. Yes.
Item 18.
and granting bail to the petitioner and directed to the petitioner to file an affidavit regarding criminal antecedent. And also affidavit also filed. The present petition contributions 19/10/2023 matter and FIR against unknown culprit. And as it was submitted on 13/2/2024. And the only case was based on only circumstantial evidence that is extrajudicial confession after 1 month of occurrence. Please, 302, you have proceeding. My lord, significant. Munna Pradip Kishore Das.
Yes, my lord. Admittedly, my lord, there is no direct evidence. But my lord, the postmortem report and in the postmortem report is cerebral injury. And the laceration wound partial area and occipital area, my lord. And what happened, my lord, that the extrajudicial confessional statement is 2 numbers there. One is this petition is Khudi, Kavita,
Okay.
Kavita Bhauja, Kavita Bhanja, and Nanda alias Gyanendra Das. Nanda alias Gyanendra Das.
Gyanendra. After 1 month of
The
same IQ was given extrajudicial confession.
My lord, I'm just reading one Kavita Bhanja, the producer of this petitioner. ଆପଣଙ୍କ ଆମ ଘରକୁ ଯିବା ଆସିବା ମୋର ସ୍ୱାମୀ ବାହାର ରହୁଥିବାରୁ ପ୍ରାୟ ସେ ମୁନା ଆମ ଘରକୁ ପ୍ରାୟ ଯିବା ଆସିବା କରେ ମୋ ସହିତ ଫୋନ ମଧ୍ୟ କଥାବାର୍ତ୍ତା ହୁଏ ଆମର ଭଲ ମନ୍ଦ କଥା ସେ ବୁଝାବୁଝି କରେ ଗତ 24/23 ସକାଳେ ଆମ ଗାଁର ଜଳଗୋବିନ୍ଦ ଦାସର ମୃତଦେହ କେନାଲରେ ଭାସୁଥିବାର ଖବର ପାଇ ମୁଁ ସେଠାକୁ ଯାଇଥିଲି ସେଇ ଘଟଣା ପରଠାରୁ ମୁଁ ଦେଖିଲି ଯେ ମୁନାର ଚାଲିଚଳନ ପରିବର୍ତ୍ତନ ଆସିଛି ସବୁବେଳେ ଚିନ୍ତାରେ ଥାଏ ଘଟଣା ପରଠାରୁ ସେ ରାତିରେ ଘର ଭିତରେ ନ ଶୋଇ ଘର ବାହାରେ ମଶା ଧୂପ ଲଗେଇ ଶୋଉଥିଲା ଗାଁକୁ ପୁଲିସ ଗାଡି ଆସିଲେ ଦୌଡ଼ି ଯାଇ ବାଡିଆଡେ ଲୁଚୁଥିଲା ମୁଁ କଣ ପଚାରିବାରୁ ସେ କହିଲା ଯେ ସେ ଓ ତାର ସହଯୋଗୀ ମିଶି ଦୋଳଗୋବିନ୍ଦକୁ ମାରି ଦେଇଛନ୍ତି ଘଟଣା ପରେ ବିଳମ୍ବିତ ରାତିରେ ସେ ଜାଣିଶୁଣି କଟକ ପଳାଇଥିଲା ବୋଲି କହିଲା ଏହି କଥା କାହାକୁ ନ କହିବାକୁ
Recorded their statement under 164? No.
No, my lord, this is only this is another one is the Gyanendra.
But let these two people go in trade. In the meantime, also take instructions regarding that case.
One thing is there, my lord, what happened. The criminal activity is in the
Otherwise, I would have given it. Yes, that is the reason, my lord, I file in no, but affidavit will not pass away because the extrajudicial confession is very telltale. Not that in the meantime, my lord, I take instruction that a case was committed. And
Gyanendra Dasagre se kaunchi my lord, jo hame to mar dechu boli.
And after vacation, we will take instruction regarding that. A person to the petitioner has filed an affidavit. How many cases are there? One cases, my lord. Up to disclosing that.
My lord, 164 statement is there, my lord. Kamalakanta Das, my lord. Informant, my lord.
If I against unknown culprit, my lord. Okay. Criminal incident is involved in PS case, Salipur PS case number 118 for 2011. For alleged offence under section 164/302/301 201/404/120B/411/34 34 IPC. In the present although there are no direct evidence against the petitioner, however, he has made extrajudicial confession before two witnesses, namely Kavita Bhanjo and Gyanendra Das. One Kamala Das, who is the informant in the present case, the statement of one Kamala Das, who is informed in the present case, was also recorded under 160. In view of the aforementioned allegations, I am not inclined to in view of the gradement of the offences,
alleged against the petitioner. I am not inclined to enlarge the petition on bail in this case. However, liberty granted to the petitioner to remain the bail plea after the aforementioned three witnesses are examined, and the trial court is directed to to see that the three aforementioned three witnesses are examined preferentially over all other witnesses. So this person is disposed of. Next. Yes.
20.
Magistrate Tribunal of Sorry. Magistrate Tribunal of 394. Allegation of snatching of a mobile and 4,000 rupees. This person has been released on bail by the landed court below.
How many cases you have?
4 cases, my lord. 379, 392. Custody.
Date of custody?
Date of custody is 6/2/2024.
6/2/2024.
Charge sheet already filed.
Who is granted bail?
By the landed court below.
You appear before police station.
My lord.
Petitioner is accused in forms of case. Allegation of the petitioner forms. Mr. Vishal and counsel for the petitioner hands up an order dated. I think that order dated 5/6/2024 passed by the learned trial court, learned ACGM Jaipur, whereby the co-accused persons have been granted bail. The petitioner is in custody from 6/2/2024. 24. Mr. Rahul, the counsel of the state, submits that the petitioner has a criminal antecedent. He has 4 cases against him. Therefore, he submits that even if the petitioner is enlarged on bail in the present case, stringent conditions should be imposed against him regarding the period of custody and nature of allegation, and the fact that the co-accused has already been granted. I am inclined to enlarge the petitioner on bail. However, with stringent condition, enumerated aid under. So we do here for 6 months minimum. Yes.
21.
No criminal lawsuit. Offenses are 302, 201, 120B, 34. And in custody since 18/11/23.
18/11/23.
23.
Okay.
2 persons are alleged, the present petitioner and a lady.
Yes.
The allegation is that this petitioner was in relationship with that lady who is a married one.
What is the name? Garba? What is
Married, the lady accused is married one, married to the deceased.
Garba Po Kartik.
Malad.
Okay.
Petitioner is Kartik. Who accused is Sunati Pal, a lady. Allegation is that they were having relationship, though the lady was a married one. And hence, in consequence of 120B, they killed the deceased, who is the husband of that lady.
This petitioner has a relationship with the deceased.
Lady.
Okay.
Lady. Her husband was killed.
Okay, the wife of the deceased. He has relationship with the wife of the deceased. So the wife and he conspired and
They conspired to kill him.
my lord. And
The lady is on bail.
because she has only, she might have conspired only to eliminate the husband to marry you. You might have done everything. So that is
There is no eyewitness to the appearance.
let us see. Yes. What are the
My lord,
completely. Yes.
You will see my kindly turn to page
Yes.
30,
30.
what happened, my lord? That was the last scene theory of one single statement of the person. Your lordship has been pleased to direct the concerned court below to first examine that last included person's environment and then report has been with your lordship.
has already
Yes, his last order is that. Second witness to the last in theory,
Yes,
and the decision has already been examined in the present case and want to place on record the evidence of the witness. You are supposed to place on record.
That's already been examined.
EW?
One, that is available on the lordship's board.
Okay, okay. These are there. Have you seen it?
my lord, no, my lord, I have not seen because that has been obtained by your
See, I'll tell you, there are 14 witnesses have already been examined. All the evidences are there.
But he is saying that here that he has seen to
I am not read it. Have you gone through? You just go through and process. You have all the 14 witnesses. Yes. Please give it. I'll put it next. Already given. You just see it. No. He has been satisfied because 14 witnesses are there. I'll put it next week. How next week? I have 120B. I will be prejudiced if she is on bail and I am in jail. No, that's right. But what are the evidence? I don't know. Right? Because now what will happen? Can you see? Pass it over.
pass it over.
No, I'll just pass it over. Just try to legal out. Because there are 14 witnesses, Germany who are there.
And also Sangram has been examined.
So therefore you must check out. You don't want. Ask that. Let it be tomorrow then. Saturday. Saturday, there is very less number of matters. Tomorrow. Treat it all. And if you don't want to come tomorrow, that's a different. I want that you should get bail. Well, your lordship will consider only one aspect. It is a she is outside jail, she is on bail. She will at any cost try to see that there are 2 accused only. Everybody is 120. Then who is in jail? So we will get to that if she is outside, if both are in jail, that then it will be recorded. But who has done 302? No, 120.
Principle of
My only point is, who will be privileged to the other one is on bail? That is the only thing. And cases have been examined, so that you know. How is your keen to come out because your girlfriend is there out? Not only that, parents are HIV present. There are many other aspects. Yes. CD has come, my lord. Last time there was the order. My lord. Yes, CD is there?
Yes, ma'am.
Yes. Yes, madam.
Initially, FIR law number section 365 IPC, my lord. During the course of
You are in
custody since.
One is the 13/7/23 and another one is the 13/8.
423.
Okay.
Charge sheet submitted under section 364.
There is only one accused.
No, my lord. Two accused.
There are 2 matters.
My lord.
2 different matters. Okay. Yes.
My lord, there is no direct evidence against the present petitioner. Only the circumstantial evidence against the present petitioner. And there is no link to connect the present petitioner and the said crime, my lord.
My lord, it's been submitted to execution.
PW. One is the informant, another is the confessor.
Yes.
We have PW1.
Charge sheet has been filed.
Yes, my lord, charge sheet already filed and trial already commenced, my lord. Out of 45 witnesses, 2 witnesses already examined.
Madam, how will I know? Because except the rejection order, you have not filed anything. That's the whole difficulty.
Perhaps more notification is there, my lord. The deposition, copy of the deposition is there, my lord. I have on the last occasion, I have supplied the copy of the deposition, my lord.
Yes, depositions are there. Yes.
My lord, this is a murder case. And dead body has been recovered after 1 month. And there are many things that my lord, I have to verify.
You have to verify. The depositions are there. You can very well see.
Yes, ma'am.
Just check it up. Okay. Release it immediately afterwards. Yes.
After holidays, Puja holidays.
Just immediately after. Yes.
23.
Yes, sir. Offense under section 20 second seal of it. Inquiry 20 second seal of it.
Yes.
So far as custody since since 26 to 2022 lordship.
26 to 23.
24 lordship.
24. Okay.
24 lordship.
Yes.
quantity of the ganja and commercial.
How much?
Lordship, there is no conscious person, Lordship. This important.
What is the quantity?
Quantity, Lordship, 100 kg, Lordship. But 100 kg, Lordship.
Okay.
But there is no any conscious person, Lordship. And so far as
He was freed away from this spot. And
that
the person has been identified the one of a grammar.
he is a grammar,
Village grammar.
one village to but his grammar.
There is no position. He was not arrested from the spot.
Lordship. As because of criminal accident, they are
Read that evidence. Who is identifying him?
Relevant part. ବାଟରୁ ଗଲାବେଳେ ଦୁଇ ଜଣ ସାକ୍ଷୀ ନେଲୁ ସ୍ୱୟଂ ସେଥିରେ ସେମାନେ ରାଜି ହେଲେ ଆମେ ତମକୁ ସାଙ୍ଗରେ ନେଇ ଗଲୁ ମିଳିବା ଘଟଣା ବିଷୟରେ ଦିବା ପ୍ରାୟ 1:45 ମିନିଟ୍ ସମୟରେ ଆମେ ଖଜୁରୀପଡା ଗ୍ରାମର ଛକ ନିକଟରେ ପହଞ୍ଚିଲୁ ଆମକୁ ଦେଖି ଦୁଇ ସନ୍ଦିଗ୍ଧ ବ୍ୟକ୍ତି ଘଟଣାସ୍ଥଳରୁ ଜଙ୍ଗଲ ଆଡ଼କୁ ଦୌଡ଼ିଲେ ବିଶେଷ ସୂତ୍ରରୁ
ସନ୍ଦିଗ୍ଧ ବ୍ୟକ୍ତି
ଜାଣିଲୁ ଯେ ତାଙ୍କ ନାମ ହେଉଛି ଉମେଶ ନାୟକ ଓ ସଞ୍ଜିତ ଖଟୁଆ this person is ସଞ୍ଜିତ ଖଟୁଆ and ବୌଦ୍ଧ ଜିଲ୍ଲା ବୌଦ୍ଧ ବୋଲି ଆମେ ତନିଖି କରି ଜାଣିଲେ ଏବଂ ତାଙ୍କ ବ୍ୟାଗରୁ ଗଞ୍ଜେଇ ବାସନା ହେଇଥିବ ଜାଣିବାକୁ ପାଇଲୁ ସଙ୍ଗେ ସଙ୍ଗେ
ଜାଣିବୁ କୋଉଠୁ ଜାଣିଲି
from this spot matter.
How they came to know that these are the two persons? Somebody might have said
they both have been freed out from the
but they moved I knew them earlier.
Grammar of because he belongs to the same village.
Grammar, you read grammar of his evidence.
Reading my grammar of his Sapteshwara Kumbhara. Sapteshwara Kumbhara.
Sapteshwara
Kumbhara.
He is the only guy who has identified them. Identified them.
And he is also police personnel.
He is the
only person who has been identified.
So then he has to be examined first. Sapteshwara, what is his name?
Sapteshwara Kumbhara.
Sapteshwara Kumbhara.
Earlier presentation can be for this honorable court lordship in ABL.
What happened?
Lordship in this case for surrender and as because criminal acting is there, lordship.
37 is already
Lordship.
Sapteshwara Kumbhara. After Sapteshwara Kumbhara, who has identified the present petitioner.
But lordship is police personnel, lordship.
Allegation the petitioner is that he has fled away from the spot from where
my lord, I mean, my lord, there is one antecedent also.
I know that, that's why I'm not granting. Right out. From the spot along with the co-issue. There is a recovery of 100 kg of contraband ganja. Contraband ganja. One Sapteshwara Kumbhara, the grammar key has identified these people while identified the people and informed the police regarding the identity of the projected case. Regarding to the antecedent of the petitioner and the nature of the acquisition, I am not inclined to elaborate this on the way. However, the petitioner is given liberty to renew the bail fee after this the witness Sapteshwara Kumbhara.
Prefer expedience trial. Prefer expedience trial.
Next. 24.
Yes.
Yes, sir. 24 minutes in the last occasion, my learned friend who is appealing for the informant, he has stated that there is a voluntary transaction between the petitioner and the informant victim. Both are major, both are having in a relationship manner.
In 76.
Manner.
Yes.
He has given the statement from 2020 to 2023. 23. That bench is given. And the amounts are example the amounts are କେତେବେଳେ 1200 ଟଙ୍କା, କେତେବେଳେ 1500 ଟଙ୍କା, କେତେବେଳେ 1700 ଟଙ୍କା, କେତେବେଳେ 2200 ଟଙ୍କା, କେତେବେଳେ 4000 ଟଙ୍କା, କେତେବେଳେ 10,000 ଟଙ୍କା, ଏଇ ଟାଇପର ହେଲା
ट्रांजैक्शन
से ताकू कौन करछन ना सब ट्रांजैक्शन को टोटल कर दूंगी बैंक ट्रांजैक्शन करछन 2,20,315
You are in custody since?
yes I am in custody since
2024.
Huh?
8 March 2024.
24 charge sheet already filed my lord.
How much you taken from her?
Statement that is true.
But you are taking installmentally. Because you are in relationship taking money also.
That महाराष्ट्र रिचार्ज कले
You should have given her. It's not that you are taking money.
the victim is I was saying actually relationship with
You pay me the money, I'm enlarging you. At least get, you are in relationship. There's no doubt about it. How can you take money from the lady like this?
से 1200
You pay 164.
My lord,
कोड खाइले
काम करे मो हॉस्पिटल रे शेखर बेहरा को हेमंत शेखर बेहरा को आगुर जानी मोर क्लासमेट थिला सेठारे से जब मोर भल होइतली कहितला मो देखितले मते से देखाबे पई कहला मते संकर 2019 रे देखाइतले मते को कागला पर रुए तापर मो होटल को फेरी आसी किछ दिन पर से कलिंग नगर रे थिवा गोटे घर को नै कि गला
I paid and granted. I will not write anything. That's the best way of doing it.
Kasugudu lordship no impose. Kasugudu lordship no impose, it will be disbursed to her.
Having 376 cash security, this is the practice.
So that
Taking the money, I will not say anything on the cash.
lordship no impose.
Listing it 2 weeks before vacations, and you tell that otherwise I will reject it. Tell him. Reject it and you need to go to there.
But I'm going to jail already. Look, I'm going to jail already. Instruction. Lordship may impose
I'm not a recovery agent for the women. I'm just suggesting you. You have taken it. Otherwise, you are not entitled to be.
But that's a good thing. It's
What is wrong with 376 cash security? What is this? It's 420 or what? Cash security. We are not requesting your client to pay. Either pay or stay. If he is not willing to listen to you, then you have to suffer. How can you 376 security?
सब पैसा देउछ एक्चुअली सेटा पैसा लब्बे जीवन सेटा मिसिक रहउतले
Installment नवार जीवन एडमिट कर नवार
ए कोड आइलस कोड आइलस को जाइथबे कि कोड खाइथबे कोड रेस्टोरेंट बसथबे कॉल करथबे 1200 1300 1500
I've taken them. And what about the allegation? Usually cold drinks, if one is unconscious, you have raped her. How will you get out of it? 164 statement is the direct allegations. And she doesn't say that we are in relationship.
that is
That's the two danger is there. Therefore, otherwise I would have granted him both. So I am giving it right.
yes.
Some justice should be done to the women, you know. Yes.
25.
My lord, they have shown in the account 2 lakh or so.
I will give something. If not full amount, give some 1 lakh. No, I go to
25.
yes, 25 CD. Is there?
it is there.
Non-APS in the inter-subject schedule. Yes.
26.
Urgent my lord, please.
Your lordship,
My lord, put it.
Hmm?
Put it.
2023.
Yes. Yes.
The 164 statement is at page 12, my lord, at page 12 and issue 2.
164.
My lord, Mu Babita Behera, Swami Sumit Behera, the petitioner, my lord, present petitioner.
He is the husband of the victim.
Oh.
Oh, my lord, they
Petition and they got married.
My lord, in last occasion, my lord, the honorable coordinate bench has been directed to the court below, my lord, for the trial of this victim, my lord. And her deposition is perhaps
My lord, in the
Victim. There is a victim.
Gal is now 18 plus.
Yes, it's there. Below one. Shamal Behra. Victim. Yes.
Victim is my lord
the-
Kavita Behra.
Babita Behra.
Kavita
Behra.
Babita Behra. Her statement is not there.
My lord, relevant but I may be led.
Yes.
My lord.
Now what are you reading? 164.
My lord.
No, last order just see, the order of this court that has to be complied. Order of this court says.
Last order.
So letter has lordship means he complied, may be complied. That is
See,
the
on the
letter.
1/8/2024, it is said that in such way, trial court shall do well to examine the victim as the first witness.
Already examined one letter
Where is that?
from the
That
court
is-
below, my lord.
That is what I am asking, madam. Victim is,
Noting is there, my lord.
Acha, daughter of yes. Yes, I am the informant come victim. In the present case, I know the accused persons, the incident took place in 2000. I have, however, with the witness and with the marriage, impossibility to prove me from my house and kept me in Burville, and from Burville to Delhi, and he kept Burville also uncle for one day, and thereafter next student is also where we were seeing the one to the mother. And they are they married and relationship were the right of petitioner is accused in so on so forth. Allegation is the petitioner and so on. The matter was taken up by this by the coordinator bench of this court on 1/8/2024 and directed the trial court to examine the victim as a first witness. Subsequent thereto, the victim has been examined by the court below on 30th August 2024 as PW1. She in her testimony has stated as under para 2 and 3 flag Z para 2 and 3. The perusal of the evidence form part of the record reveals that the petitioner was with the victim prosecutrix, and on the pretext of marriage, he has kept a physical relationship. They have been living in Burville, thereafter in Delhi. Delhi. Petitioner is about 20 years of age, whereas the victim girl is, victim girl is 18 years old. 18 years old. So paragraph it's not a sexual exploitation and all, and granted base. Yes, granted. Yes, it's custody since 12/11/23. Take it. I'll just stop.
चार्जशीट has been filed, my lord. चार्जशीट has been filed and dated 12/6/2024, my lord. 12/6/2024.
Petitioner is agreed by 12/6/2024. 12/6.
My lord. Aye.
24.
Yes, my lord.
12/6/24.
Well, petition is agreed by the order dated 22/12/2023, whereby his bail plea has been rejected. Subsequent thereto, on 12/6/2024, charge sheet has been filed. In the changing circumstances, petitioner seeks liberty to renew the bail plea before the trial court. If such bail plea is filed, this this is about the material forms part of the charge sheet. Yes, next.
29.
May I please your lordship?
Yes,
May I please your, I am on VC, my lord.
yes.
My lord, the petitioner is in custody, my lord. It's 31/3/2024.
31-3.
My lord, 31/3/2024.
Yes,
My lord, the offences alleged against him are under section 420, 467, 468, 471, 294 and 506. And all the offences are tribunal magistrate, my lord.
yes.
The background of this case, my lord, this first information was not accepted by the police, for which, my lord, a 1cc case was filed, and that was referred under section 156, because
Yes.
initially the petition informant in this case, my lord, is the landlady. I have taken his house, my lord, on rent for a business purpose. And I was doing my business in his premises, my lord. After some time, the petitioner, who is a lady, and her husband, they expressed their desire to become partner with me.
Yes,
They invested some amount as partners with me, my lord, and both of us, my lord, continued the business. Certainly, my lord, there was a loss in business, and there was a dispute for which, my lord, he wanted that I should vacate his house. I did, and there was some dispute, my lord, for which he lost the FIR in the police stations to vacate me, and I have also passed that, my lord, case. And subsequently, there was a compromise. Again, I continued as a tenant, and both of us were having common business, my lord. And a partnership deed was executed for the purpose of business, which is the annexure, my lord.
yes, I understood it. Yeah, in case where the closure report was filed, and for the then 1cc case was filed thereafter. And
There is transaction, my lord, that is.
And for the informant, my lord, let my brother submit thereafter.
and in a protest petition, all these things has happened.
My lord.
Yes.
25 lakh, 70.
Let me finish. Yes, your lordship.
Yes,
May I be permitted, my lord? Let me
Yes.
finish in 2 minutes, my lord.
I understood it. I'm just asking.
I will just point out one question, one thing, my lord.
Yes,
With lordship's kind permission, your lordship kindly see section page 32. Page 32, my lord, is a partnership deed,
yes,
and at page 39, my lord, your lordship kindly come to page 39,
Mhm.
para
Yes.
30, para 31.
31, yes, I'm there.
All the dispute, but your lordship got, my lord?
Yes, right there.
All the disputes
The
between,
arbitration clause is there.
yes, my lord. And in
Yes.
spite of that, I am facing a criminal case.
Yes,
My lord, the kindly turn to page 19 for a moment.
19.
Yes.
Yes,
My lord, may kindly peruse paragraph 5 of the learned trial court, how he has dealt with the matter.
Hmm.
My lord,
these things are tried to see in detail.
correct.
The report was filed.
My lord, I am on the point. I am on the
And there is
point.
an arbitration clause.
Yes, I am on the point.
Custody, what do you want?
Custody.
So this is lesser practice. Supreme Court has repeatedly said that in a business transaction, it's a pressure.
I understood, Mr. Tell me.
My lord, may kindly see the amount involved. He has, during course of discussion, he also complained that he will pay 18 lakhs towards her contribution being a partner of the firm. Thereafter,
You have an arbitration clause on this.
the amount of money involved is 79 lakhs. Your lordship,
These are not recovery proceedings.
my lord, I'm aware. My lord, your lordship may secure that money. I'm not saying that he will deposit the money in court. I am aware of the Supreme Court judgment. I'm aware. But he should give some property security of like amount. So that
I can't insist for that. And if you make, I can make an observation that you can endeavor to settle the dispute. That is a monetary transaction.
he should secure that money. He should go on bail. He may go on bail. But
Mr. Naik, what is your response to the suggestion made by him?
Your lordship knows, my lord, the secured money, Supreme Court has said that this is the court.
I'm not understand it. I know that. I'm not here as a recovery agent, but what is happening in the ground reality, one should understand. Yes, Supreme Court judgment is there, no problem. But the ground reality is this: if you can settle the monetary transaction, if you can settle nothing like that,
No, your lords, I am prepared to settle your lordship and grant me bail. Direct both parties.
Petitioner is accused on so and so from. Yes, sir. Allegation against the petitioner.
So lordship may note that I have approached.
Yes, yes.
Lordship may refer to mediation.
Initially, the FIR was registered against the petitioner at the instance of the opposite, instead of at the instance of one.
The complaint was filed by
Yes. Sanjukta Panigrahi. Mr. Bose is appearing on behalf of the said informant. After investigation, the closure report was filed by the police. Subsequent thereto, a protest petition has been filed in which 1CC case was filed, in which the out of which the present case is arising out of. The Mr. Naik and counsel for the petitioner is relying upon where is that paragraph you are showing here?
Annex 3, Annex 3,
did placed as Annex 3. He has brought to the notice of this court regarding the arbitration clause regarding one of the said document, which reads as under 31. 31 of Annex 3 arbitration clause differential. Relying upon the aforementioned document, Mr. Naik submits that this indeed did a misunderstanding arised out of the business dealing between the parties, and for which the efficacious remedy would have been the arbitration proceeding. However, the informant has resolved, filed the present criminal case. Mr. Bose and counsel appearing for the informant vehemently oppose the prayer of bail and submits that the petitioner has indulged in the fraudulent transaction to the tune of 79 lakhs. 79 lakhs. Therefore, he submits that.
I object, your lordship may record my objection. It is 38 lakhs his case. He says 75 lakhs. 38 lakhs.
78 lakhs. Mr. Naik, however, submits that into the dispute is
one case 38 lakhs.
About 38 lakhs. About 38 lakhs. Be that as it may, I am not inclined to enter into the merits of the case, but suffice is to say that the parties should resort to mediation in the instant matter. Accordingly, the parties are relegated to High Court Mediation Center. The coordinator of the High Court Mediation Center, Sir Bhubaneswar, District Court Bhubaneswar, regarding and make all efforts for settling the dispute. Okay. Settling the dispute. Regarding being head to the aforementioned and the fact that the petitioner is in custody since 31/3/2024, the nature of allegations and the fact that the parties are now relegated to mediation center, I am inclined to enlarge the petitioner on bail, and subject to condition that the petitioner shall cooperate in the mediation proceeding.
My lord must say, I'm just praying before your lordship. Your lordship may let him give some property security so that.
No, my lord. No, my lord. Mediation. It will
be the arbitration proceeding also, you need not go into.
Let the liability be fixed first. Let the liability be fixed first.
Yeah, otherwise, in these kind of cases, bail.
If it doesn't cooperate, that condition is there.
You are apprehending, I will not cooperate. I will cooperate. I undertake, I will cooperate.
No, that is the condition now. You don't cooperate and the concession bail shall be withdrawn.
We will cooperate. Why you will not cooperate? The High Court direction is there. Urgent certified copy, my lord.
Yes.
30.
Yes.
Pursuant to Miller's direction, I am filing comprehensive affidavit. And most of the cases he has been acquitted, other cases he is there.
I'm serious. How many cases you have?
10 number cases including present case.
You are in custody since?
Custody 3/10/2020.
3,
10.
10, 23.
She was remanded in this case.
Remanded in the case. In which case he was arrested?
First, when he was arrested,
Which case you were arrested?
and that is Sonpur. Sorry. That is Bolangiri town. Case number-
Last time also I asked the same thing. You tell me which case you arrested. I will have to.
Bolangiri town
Bolangiri town PS case number 409/23.
10/8/23.
Okay. You have been,
Charge sheet has been filed.
no, you have been taken into remand in all the cases.
My lord, in all the cases have been taken on remand. The cases cited, in most of the cases have been acquitted, in other cases I am there.
How many cases you recruited?
My lord.
एक दो petition is accused in so case, allegation against the petition and so on. Pursuant to the direction of this dated 12/9/2024, the petitioner has filed an affidavit in Prelia enumerating the number of cases pending or the pending oblique acquitted pending against him. Mr. General and Counsel for the petitioner submits that the out of 10 number of cases, in 9 number of cases, in 10 cases, 9 number of cases, including this 10, 9 number of cases, in many cases he has already been acquitted. He was initially arrested in
Bolangiri town
case number.
Bolangir PS case number
Bolangiri town PS case number
409.
409 of
2023.
2023. During his custody, his confessional statement was recorded. On the basis of the confession, the present case, in the present case, he has been taken on remand. पूरा detail, ठीक है. Petitioner is in custody since 30 Sibo Sankar 2023. Regarding to the nature of the allegation and the fact that in many cases he has already been acquitted, and in the present case he was taken on remand while he was in custody in another case on the basis of his confessional statement. I'm inclined to enlarge the petitioner on bail. However, Mr. Misconduct and Counsel for the state submits that submits that owing to the number of antecedents against the petitioner, the petitioner shall be put to stringent condition. Stringent condition. Granted bail, and he has to appear before the police station on every Sunday for about 6 months. 6 months. Yes.
31. Minus 31 is 302. CD has not yet come. Tomorrow CD will come because this is Misconduct piece.
Yes.
Yesterday, your lordship directed.
9.
Pray for tomorrow, my lord.
No, tomorrow CD will come. Because personal appearance of the-
Personal is a lady, his not name is the FR also. FR is also unknown, my lord. Pray for tomorrow. If
No.
From where it will come?
My lord, it is come from Misconduct. Yesterday, tomorrow, the personal
There
appearance.
is no flight from Misconduct to Cuttack. There is no flight.
on
Because my lord, personal
He's
appearance.
saying it will come tomorrow.
Monday, my lord.
Good. Monday, Tuesday लगा. ठीक है.
Of like
It is a 302 case.
blood three.
You are sure that you will get
It's
it.
not this lady, my lord. FR is unknown, my lord. That's why I am.
Anyway, let us see.
May it please, Your Lordship.
There-
That's it.
अच्छा सुमिता, अच्छा he is Sumitra and he is Sumitra. Okay.
Sumit Patra.
Okay. I got confused. Yes.
I'm in custody since 29 2024.
29?
April.
29/4/2024.
24.
Yes.
Okay.
Allegation is 21B.
170 gram brown
Brown
sugar,
sugar, yes.
which is less than the.
And incidence
No incident.
170.
170. Yes. With some condition. With some condition.
170 gram brown sugar, custody from 29/4/2024. Subject to verification of, subject to verification, yes.
Hon'Ble.
33.
33 my lord, 376, what is section 4 and 6 of the POSCO Act. The last occasion, Lordship has
Custody?
directed, yes, custody since
3/5/2024.
24.
3/5/2024, okay.
The victim has been examined, she has given the clean chit to her brother-in-law. I have filed the copy of the evidence. You see, yes, PW1.
Now, what are the offenses?
373 and 4 and 6 of the POSCO.
Notice was issued?
Yes, yes.
Notice was served on 10/7/24.
Yes, yes. Despite notice to the informant prosecutrix, none appears, sir. You have shown the evidence.
Madam, that is, I have filed
Yes.
under annexure.
Have you seen it?
I marked those. Thanks. So he has given 164 statement against the brother-in-law. He is the victim is the sister-in-law.
Okay.
So, in the deposition copy, she has she's given clean chit to the present petitioner and alleged allegation against another one person.
But in 164, all allegation against.
My lord.
And
DNA profiling
doesn't match with me.
DNA profile also does not come.
Match.
So, क्या है? Let us see. Let us understand the fact then.
But Lordship may kindly peruse Chief Examination Para 2.
Para 2.
Para 2.
Para 2.
About 3 months back on a day.
1 minute. Para 2.
Para 2.
PW1, huh?
PW1.
E1. Here.
Para 2. About 3 months back on a day, I had disclosed
Yes. About 3 months back.
3 months back, I had disclosed before Anganwadi Didi about my relationship with a person having name as Sanjay. I was pregnant.
Are you?
Bahadur Sagar.
Yes.
I was pregnant of about 7 months. I had gone to medical and made phone call to one Sanjay of village Dangojola. Whereas he did not receive my phone call, the said Sanjay threatened me not to disturb him by making phone calls repeatedly. My brother-in-law, the parent petitioner, had come to our village and he told to
Sanjay's brother. Sanjay's.
I am the brother-in-law of the victim. I married the elder brother, elder sister of the victim.
Yeah. My brother-in-law.
Yes. Convey a village meeting. Accused one told me as the said Sanjay would not take me with him, I should stay in his house till delivery of my child out of my pregnancy.
Okay.
He further told me that he would take care of my child after delivery. I had made phone call to said Sanjay and my brother-in-law told him for his relationship with me. Pregnancy. However, the Anganwadi Didi has initiated this.
Yes, he is against my brother-in-law.
But the name of the Sanjay first time came in the deposition.
Sanjay is not an accused.
Sanjay is not.
319 dialogue.
319 law.
319 dialogue.
Petitioning the accused in so and so case. The victim, prosecutrix. 376, na?
376
Age of this girl?
My age is 15 years because date of birth is 17/2/2009.
Victim in the present case has been examined as PW1. PW1. She in her statement has taken a completely different stand. Her statement in para 3 of the examination chief reads agenda. Para 3, para 3. Para 3 statement. We will say that. Next one. Petitioner is accused number 1, who is stated to be, who is the brother-in-law of the victim. In the statement, the victim has exonerated the petitioner fully. even the DNA test conducted has not supported the prosecution. Well, not supported the prosecution. In view of next one, the petitioner is in custody since 3/5/2000. In view of the testimony of the victim girl and the medical evidence, including the DNA test, and the fact that the petitioner is in custody since 3/5/2024, I'm inclined to enlarge the petition on bail accordingly granted bail. Yes. Okay.
The petitioner is under the custody is 17/4/2024 for the alleged offense under 409 for 20 IPC, sir. In this case, the prosecution story is that, sir, petitioner is a assistant customer relation manager in Ujjivan Small Finance Bank Limited, Sambalpur, committed criminal breach of trust and misappropriated a sum of rupees 8,04,550 rupees from 15 customers of the bank.
Yes.
Actually, misappropriation of 8,04,550
from the informant.
from the informant.
Yes.
And
Informant, no, sir. 15 customers of the bank.
15 customers.
Sir.
Informant means the informant.
the bank man.
Bank branch head.
My submission,
Before, if my learned senior wants to complete,
completed, I understood it.
only one, I'll take your lordships to only one document.
Tell me the facts.
Well, facts is it's fraudulent transfer of money from the account, loan account of different customers.
Who was your employee?
Yes, Madam.
Yes.
And that is amounting to 8,04,550. Out of the said amount, there is already a recovery of rupees 2,53,593. Balance is 5,50,957. And there is this has been admitted by the petitioner regarding this misappropriation with an assurance to repay.
Where is that?
That I have annexed page 5. Please. It is at flat C.
Yes.
Flat C. I filed it by way of an affidavit. Annexure 2, page 5. Only 2 sentences I will read out. This is this. Mu Subham Kumar Naik. Mu nimno customer manankar loan paisa nechi. Au mu ehi sobu customer paisa madhya debi. So there is a clear admission.
You have to pay back. I am enlarging you on bail, you pay back the money.
sir, it is not a part of record, sir.
It's
However,
all-
in this,
Forget about that.
sir,
Part of
net,
taking money from me. You have to pay back, that's all. I am granting you bail.
sir,
Condition that release of the bail, you have to pay it back, that's all.
If you go to the part of the record, then the amount is 7 lakhs outstanding.
And why are you getting into all these things? You pay back and
Because the
but
asset sale.
sir, prosecution submitted employee statement in this, in that record, sir, still put into the.
you simply tell me whether you want to pay or you want to remain in jail. Answer me.
It is a threat.
Then instead of dividing, you have siphoned it. It is your admission, own admission.
And customers' credit cards also, debit cards also seized from the present petition.
What to do? How many days you will keep?
If they want to buy some time, they may file an affidavit.
There is no such record, sir, of customers
Comes out that you will pay.
or any statement in the record, sir, to misappropriate the amount will. sir, କୌଣସି ପ୍ରକାର ରେକର୍ଡ ନାହିଁ ଯେ କଷ୍ଟମରରୁ ଆମେ ପଇସା ସାର୍ ଆଣିକି ମିସଆପ୍ରୋପ୍ରିଏଟ୍ କରିଛୁ ବୋଲି।
Doesn't want. Please sit after vacation. If you don't want to pay, it's all right. Be there inside jail.
Sir,
Yes.
since sir 5 months, 6 months ହେଲା ଆମେ ଅଗଷ୍ଟରେ।
It's not suggesting you don't want to pay. You have taken money from many people and see the kind of money you have taken. And if you are adamant not to pay, you go inside jail for after some time you will understand what has happened. Yes, after vacation. If you want to pay, I will release you on bail right now.
I am trying to pay, sir.
Not trying, you have to. What trying? You've taken money, you have admitted by writing, and bank is the complainant. Bank is not an individual.
Sir, the record is sir manipulated, sir. जो complaint जो भेजो
Don't argue with me, then I will give it in my merit after vacation. Please after vacation. Next. You can't waste time like this. If you want on merits, then we'll see. After vacation. May I please ask you? Yes, I'm 30 same here per man. 30, 36, same here per man. 35 and 36 are. I'm custodian charge and where come.
Yes, madam.
Yes, I'm custodian charge and we have 24, charge 524. Fine. Final form date my lord, 31/8/2024. 31/8/2024. Okay. Yes.
Charge sheet submitted 31st.
Yes. What are the allegations? And yes,
46 kg, 910.
bottom
From two persons. From two persons.
from the railway station. Antecedents? No, man, local man, not here.
From the first petitioner, that is 25 kg, and from the second cooperative person, 21 kg.
21 kg.
Minor. From Tilothan minor, this is 25 kg, 905.
Pudlotan 25 kg. The other one?
Other one is Amit 21 kg, 5.
Amit Kumar. 21 kg. No antecedent. No, madam. No, man. Subject to verification. Okay. They are in custody since 4/5/2024. Okay. Yes. Charge sheet has been filed. Yes. Please.
Please, madam. The petitioners
Yes.
have been forwarded under section 366, 372, 373.
There?
CD madam.
Yes.
12/4/2024 custody madam.
12/4/2024.
madam.
24. Okay.
366, 370 bracketed 2, 378/34.
Yes.
Both are from Madhya Pradesh madam. There's a husband and wife. Petitioners are husband and wife. Both are belong to Madhya Pradesh. And madam 164 of the victim madam. I'm reading the relevant portion.
Right.
Though 370 is there, madam, but they have no victim has not stated. Only relevant portion. Prakash present petitioner. ଆମ ଘର ପାଖରେ ପରିବାର ସହ 5 ବର୍ଷ ହେଲା ରହୁଥିଲେ। ମୁଁ ତାଙ୍କ ଝିଅ ବର୍ଷା ସାଙ୍ଗେ ବହୁତ ଭଲ ସାଙ୍ଗ ଥିଲି। ପ୍ରକାଶ ଓ ରମାଦେବୀ କହିଲେ ମତେ ଆମ ଝିଅ ବର୍ଷା ଘରକୁ ଚାଲ, କିନ୍ତୁ ମୁଁ ହଁ କହିଲି ଏବଂ ତାଙ୍କ ସାଙ୍ଗରେ ଗଲି। ମତେ ସେମାନେ କହିଲେ 2 ଦିନ ବୁଲିକି ଆସିବୁ। ଆମେ ତାପରେ ଗଲୁ। ଦେନ୍ ମାନେ କିଛି ଦିନ ରହିଲା ପରେ ପ୍ରକାଶର ମାଉସୀ ପୁଅ ରାଜୁ ରକଡ଼ ଆସିଲେ ମ୍ୟାରେଜ ପାଇଁ। ମୁଁ ରାଜି ନଥିଲି। ମୁଁ ମୋର ବିନା ଅନୁମତିରେ ମତେ ମ୍ୟାରେଜ କରିବା। ମ୍ୟାରେଜ ରଜତର ବାପା ମା ଆଉ ରିଲେଟିଭ ଆସିଥିଲେ। ପ୍ରକାଶ ଓ ରାମଦେବୀ ମଧ୍ୟ ଥିଲେ। ସେଠି ମ୍ୟାରେଜ ସରିଲା। ରଜତ ତା ଘରକୁ ଗଲା। ରାତି ହେଲା ଯେମିତି ରଜତ ତା ମା ମାମୁଁ ଏବଂ ରମାଦେବୀ ଗୋଟେ କ୍ୱାର୍ଟରରେ ଶୋଇଲେ। ରଜତ ଡ୍ରିଙ୍କ କରିକି ଅଲଗା କ୍ୱାର୍ଟରରେ ଶୋଇଥିଲେ। ତାଙ୍କର ସହିତ ମୋର କିଛି ରିଲେସନ ନାହିଁ। ସେ ମତେ ପିଟା ମରା କି କିଛି କରା ହେଇନି। ତା ଆର ଦିନ ମୁଁ କହିଲି ମତେ ଛାଡି ଦିଅ, ହେଲେ ସେମାନେ ପୋଲିସ କେସ୍ କରିବେ ବୋଲି କହିଲେ। ତାପରେ ମୁଁ 112 କୁ ଫୋନ କଲି। 3-4 ଥର ରିସିଭ କଲେ କାଟି ଦିଆଯାଇଥିଲା। ମତେ ସେମାନେ ଗୋଟେ କ୍ୱାର୍ଟରରେ ତାଲା ମାରି ଦେଇଥିଲେ। ଦ୍ୟାଟ ଇଜ ଓନ୍ଲି
ତାଲା ମାରି ଦେଇଥିଲେ।
ମତେ ଖାଇବା ପାଇଁ ଥରେ ଦେଉନଥିଲେ, ଖାଇବା ପାଇଁ ଥରେ ଦଉଥିଲେ। ତା ଆର ଦିନ ମୁଁ 12 ଡେଇଁ ପଳେଇ ଆସିଲି ଏବଂ ଅଧା ବାଟ ଆସିଲା ପରେ ରଜକର ବାପା ମତେ ତାଙ୍କ ଘରକୁ ସେଠି ନେଲେ ଏବଂ
Rajat is their nephew.
No, is the ପ୍ରକାଶର ମାଉସୀ ପୁଅ ରାଜୁ ରକର।
Cousin brother of this accused person. And what they did? They arranged the marriage.
Only arranged the marriage and they were present in the marriage. But 376, 370A, 372 is there. Charge sheet. But she has not stated anything.
Nothing is mentioned. Petition is accused. And so also allegation is also. The victim girl, the statement of the victim girl, who is stated to be, what is age?
Her age is 18 plus, 18.
18 years. Was recorded by the recorded under 164 CRPC during the investigation. She has stated that she was having acquaintance with the present petitioner. She was asked to accompany them to where?
To their sisters.
To where? Place.
MP.
To their relatives' place at MP. There, these two petitioners were becoming instrumental in getting her married with one Rajat. Getting Rajat. This Rajat, there are allegations against. She has already also stated that the Rajat has mistreated her and confined her in a house. There is no specific allegation made by the victim for offense under section 376 IPC, even against Rajat, even against the Rajat. The only allegation against the present petitioners are that they are introducing and getting the victim married with Rajat. Rajat. The petitioners are in custody since 12/4/2024. Regarding head to the charge sheet has already been filed. Charge sheet has been already filed. Regarding head to the nature of acquisition and the statement of the victim recorded under section 164 CRPC and the period of custody from 12/4/2024. I'm inclined to enlarge the petition on bail. तापर लिख दो outside present address PR bond वाला लिख दो PR bond ठीक है. Present and they will also the petitioners will also file the present address. Current address, yes. And PR bond.
Allegation, there is no allegation of 376, only 370A and 370. 376.
Charge sheet is filed under
370, madam. 366.
Charge sheet has already been filed in the present case for alleged offense punishable under section
366,
370,
370A and 372.
370. Okay.
Progress. 38.
Yes, please, your lordship. Last occasion, lordship directed to file comprehensive affidavit. How many cases?
Yes.
How many cases? Petitioner is involved in 8 number of cases.
Yes.
And arrested in connection with Bargad PS case number 420 of 2022.
What is the allegation here in this case?
Allegation, my lord, the house burglary. And this petitioner is the receiver of stolen property as alleged.
Jewelry shop.
Having a jewelry shop.
44 numbers of gold ornament was seized from the present petitioner.
Okay.
And my lord, it is shop, he has involved in 8 numbers of
all 411.
My lord. And he basically
stolen, he is a jewelry shop of stolen.
Jewelry shop of stolen.
And registered jewelry
actually
since minor custody since 15/4/2024 में ना
यानी 24
आया
You are in how many cases?
8 numbers.
What is happening to those cases?
In all cases, my lord, has been granted by the High Court, also by the London Sessions Judge.
Right. Petitioner is accusing so-and-so case, allegation against the petitioner so-and-so. The pursuant to the order dated 18/9/2024, the petitioner has filed a comprehensive affidavit inter alia stating that he is involved in as many as 8 cases. In all the cases, he has already been enlarged on bail. Then consequently, the petitioner submits that when he was in custody in Bodagoda PS case number 420 of 2022, statement has been recorded, and pursuant thereto, he was remanded in the present case. He is in custody since 14/4/2024. And consequently,
10/4/2024. 10/4/2024.
24. See, the date of custody at least you should tell correctly. And therefore, what I am thinking is we will have a format, a checklist, and everything will be written there. Right. Every bill application that is filed. We are struggling to get the date of arrest, date of remand and all. Then consequently, the state submits that he is an habitual offender. In the present case, what is recovered from him?
44 numbers of gold ornament.
In the present case, 44 number of gold ornament has been recovered from him, and he is the petitioner including himself as a jeweler. However, in fact, he is involved in 8 cases. 8 cases. Be that as it may, the petitioner regarding head to the period of custody from 10/4/2000 and nature of allegation and all granted bail. and he has to appear before the police station. So he appeared before police station for 6 months. Morning you go to police station, appear, open your shop. And evening you collect.
Prior to all these cases, the petitioner has no antecedents.
Now, eight antecedents are there, you will increase your profession, why do you worry? Yes.
May please your lordship.
39. Yes.
The petitioner, my lords, is in custody since 11th of November 2023.
11 November, huh?
Yes, 2023, my lord.
Yes.
And my lord, the charge sheet has already been submitted on 24/12/2023.
24/12/23, okay.
Yes. And my lords, in the charge sheet, my lords, under section 417, 296, 376, 2N of the IPC.
Yes.
A married lady having a children, 22 years, victim. And my lord, relevant portion of 164.
Read it.
जे मो स्वामी मु बाहा हेकी सूरत रे मो स्वामी सर रहउतली सेते बेले निवासी भूया इज प्रेजेंट पिटिशन आम घर पाखे रहउतले तापर गोटे दिन मो स्वामी नथिबा समय निवासी आसी मो सहित जबरदस्ती शारीरिक संपर्क रखिला तापर मु आ निवासी भूया सूरत रे गोटे घरे रही मो स्वामी मते छाड़ी देइतले आज को 5 मास हेबा निवासी मो सहित जबरदस्ती शारीरिक संपर्क रखिछि तापर एवं निवासी मते ता मते बाहर बोली कहितला तापर मो सहित शारीरिक संपर्क मते रखितला किंतु तापर निवासी रो मां बापा मते बाड़ा मरा कले आ रखिबा को मना कले निवासी मते ता मां बापा कथार मते रखिबोनी बोली कहूची एवं मारि दे
व्हाट आर द ऑफेंसेस
माने 37621 417 294 506
granting it petitioner accused of fraud allegation against the petitioner is found during the investigation the statement of what is the age of the victim
22 years madam
22 years has been recorded. She in her statement stated that she is separated from her husband. The present petitioner has promised him to marry and forcibly kept a physical relationship. Both the petitioner and the victim stayed in Surat. Fled over to Surat and stayed there. That is what 160.
They were staying at Surat and present petitioner is the neighbor of
They were staying at Surat in their respective families. In fact, the present petitioner is also married.
No. Then everything has happened in Surat. Why the case here?
But then after she came and filed this loss, this came to
incident happened there only.
Madam?
Incident happened there.
Incident ना तापर कोई ना हमें निवासी घर को आने के रखिला तापर मो सहित शादी का संपर्क रखिला
Okay. Part of
incident was Surat part incident
and drafted by some lawyer. Yes. कौन लिखा? No. They were staying in Surat. The petitioner happens to be a neighbor of the victim, neighbor of the victim. Although he was married, however, he promised the victim to marry, and they came back to they came to Orissa, and the family member of the petitioners have not well taken the alliance. Therefore, the FIR was registered. The petitioner is in custody since 11/11/2023, and the petition 11/11/23 regarding to the nature of accusation and the fact that the petitioner and the victim were in relationship. I'm inclined to enlarge the petitioner. Yes.
Grateful.
40. That's going slow. Yeah, 44. Yes. Yes, sir.
Custody since lordship 29/3/2024 lordship offense under section 498A 304
498A
lordship 304.
Yes, lordship dowry provision. Yes, how many cases you have?
Lordship may allow me to file complaints already filed lordship. One criminal and lordship
that is also 323/506 and
that lordship minor arising out of civil dispute.
Okay, sure. What are the allegations against him? You are the husband. You are the
lordship.
And marriage was
suicidal lordship.
Marriage was held on 4/2/2024.
Yes.
Within 1.5 months, my lord, 1.5 months, this occurrence was taken.
Custody?
Custody was from 2024.
29/3/23.
20.
Okay.
Other court it was only one, Lordship.
How many accused? Only one.
No, Lordship.
What happened to them? They got bail.
They are all
Bail.
in court, Lordship.
In-laws.
In-law, Lordship.
How she died, you tell me.
My lord, PM report is poisoning, my lord.
Poisoning.
Viscera report has not yet come.
3.
And but only I have received quest diagram up to 8/5/2024. So there is no instruction that whether charge sheet was.
Charge sheet filed also. Charge sheet filed on 25/7/2024. 25/7/2024, Lordship.
Then you have to go to trial court.
Lordship, so far as statement is concerned, Lordship, all family member of the victim, Lordship, they stated that she consumed poison. She consumed
Marriage 2 months.
Not 3 months, my lord, 1.5 months.
1.5 months. And you have antecedent.
Lordship,
These are the two things.
Relating to dowry demand, the father of the deceased, he has transferred transferred 7 lakhs rupees to the
Account.
To the petitioner's father.
Lordship, no, Lordship, সেটা হচ্ছে যেহেতু ম্যারেজ প্লেসটা সম্বলপুর হইতলা সেটু ম্যারেজ র এক্সপেন্সিভ যে তাଙ୍କର সেটা যেহেতু অ্যারেঞ্জমেন্ট পাস আমাকে ଦେଇଥିଲେ সেই অ্যারেঞ্জমেন্ট সেপারে ক্রিমিনাল অ্যাকশন লর্ডশিপ কাইন্ড অফ
Subsequently, these are the things you have to.
এটা কিছু খালি দেখতে দাও ক্রিমিনাল অ্যাক্সিডেন্টটা
I've seen your affidavit.
একটা দেখে বলছি
I have not done that. I've seen it. Your character are involved in a criminal case.
No, Lordship,
Within 1 month of marriage, this has happened. Secondly, you have taken money from your husband by bank transaction. All these things are there, and
effort criminal answer effort দেখো আর একটা সিভিল ডিসপিউট আছে ড্রেনটা মানে ড্রেন বনেগলা পানি আমাদের আসলে বলি পার্টিকুলার
understand it. Your mentality is.
so I'm not at that yes, I'm not
Agreed by the order dated 16/5/2024, whereby his bail plea has been rejected. Subsequent thereto, on 10/7/2024, the charge sheet has been filed.
ছুটি প্রবাসন
No, charge sheet is filed. So therefore, the petitioner seeks to remove the bail plea before the trial court afresh. If such bail plea is moved, the same shall be considered on the basis of the materials form part of the charge sheet. On the changing circumstances. Circumstances have changed. You can't.
Dated 27/9/2024, Palestine Sarnia versus Devasis Das versus State of Odisha.
You got bail, na?
Yes, my lord, I got bail, but I'm praying, my lord, for modification of para 6 condition 6, my lord.
I'll not be modified. This at the time of grant of bail, you said that you.
My lord, I placed the certified copy of the order. Thereafter, my lord, because of I have 2 criminal antecedents.
You persuade the trial court. What you stop? If you are relying upon.
My lord, I'm relying, my lord, this honorable court's order dated 27/9/2024, Debasis Das versus State of Odisha. Instead of the criminal antecedent, there is about 6 criminal antecedent, my lord. Even after that, this honorable court considered.
How can you bring all these things here?
My lord, what happened in this case, my lord? In this case, my lord, I got red-handed, my lord, with a conscious position. Other 2 cases are, my lord, that is 2019 case and 2021 case, my lord. That case, I am already released on bail, my lord. Only small prayer, my lord.
Debasis case.
Yeah, my lord, the Debasis, I will supply the copy. Debasis Das versus State of Odisha. Recently,
Petitioner was granted bail by the order dated 25/9/2024 with various conditions. The petitioner has moved the present application seeking variation of the condition number 6. He shall be released subject to verification of similar types of antecedents. And Sahul and counsel for the petitioner by relying upon Sania alias Devashish Das, submit that the
Case
condition.
number 3 and 4, my lord.
Condition should be varied, as his case is similar to that of the case that of the Devashish Supra. Devashish Supra. I am not inclined to entertain the bill application, modification application. Application. However, if liberty is granted to the petitioner to move appropriate application before the trial court, if such application is moved, the same shall be considered in the light of the judgment of Shania.
Grateful. Grateful, your lord.
42 you want modification opportunity? Yes.
May I please?
Yes. 42. Yes.
The sir who is inside the custody driver is inside the custody since 13/4/2024.
13/4/2024.
Yes. In the meantime, final PR has already been submitted. We have filed the said PR along with that is flag A.
Flag A,
My lord. My lord. E for empty.
Okay.
Yes. Poor driver is inside the custody, my lord, and 20B2C.
Recording?
80. There's 9 of my brief. 80. Contraband ganja seized in this case, that is the PR also, 80.
80. And antecedents?
No antecedent. You got mechanically protected to that extent.
Subject to antecedent. Right now. Subject to antecedent. Outsider or
local man.
And 6 month police station. 6 months will appear. Yes.
6 months.
6 months every Sunday you go and appear. Yes.
Petitioner is in custody since 21/2024, my lord. 21/2024.
Okay.
My lord, offense under section 498/306 of IPC, my lord.
Yes.
Cause of death, my lord, poison, my lord. And
husband.
My lord.
Yes.
And at the time of occurrence, my lord, petitioner was also not there, my lord.
So that
I am giving one statement, independent witness, my lord. ଶ୍ରୀକାନ୍ତ the present petitioner ତାର ସ୍ତ୍ରୀକୁ ପିଲା ପ୍ରତି ଧ୍ୟାନ ଦେବାକୁ କହେ ଏବଂ ପଢାଇବାକୁ ମଧ୍ୟ କହେ, ମାତ୍ର ରଞ୍ଜିତା ତାକୁ ନ ପଢାଇ ଗାଁର ଲୋକମାନଙ୍କ ସହିତ ବସି ଗପସପ କରି ସମୟ ବିତାଏ। ଏହି ବିଷୟରେ ଶ୍ରୀକାନ୍ତକୁ ଖବର ଦେବାରୁ ଶ୍ରୀକାନ୍ତ ରାଗି ଯାଇ ରଞ୍ଜିତାକୁ ଗାଳିଗୁଲଜ କରିବା ସହିତ ବିଷ ପିଇ ମରିଯିବାକୁ ଗାଳି କରେ। ଏମିତି ରଞ୍ଜିତା ରାଗି ଯାଇ ଗତ 19/1/2024 ଘରେ ଥିବା ବିଷ ପାନ କରିଦେଲା ଏବଂ ଚେତା ଶୂନ୍ୟ ହୋଇଗଲା। ତାଙ୍କ ଘର ଲୋକେ ତାକୁ ସଙ୍ଗେ ସଙ୍ଗେ ଗାଡିରେ ବାଙ୍ଗିରପୁର ଡାକ୍ତରଖାନା ଡାକ୍ତର ତାକୁ ମୃତ ଘୋଷଣା କଲେ। Another statement, he
was not there.
My lord, I am reading, my lord. ଡାକ୍ତର ବିଷ ଖାଇ ଦେଇଥିଲା। ଗ୍ରାମର ଭଦ୍ରଲୋକ ଏକ କାରରେ ଡାକ୍ତରଖାନାକୁ ନିଆଯାଇଥିଲା। ଡାକ୍ତର ମୃତ ଘୋଷଣା କଲେ। ଶ୍ରୀକାନ୍ତ ଦଳେଇ ରାଗି ଯାଇ ସ୍ୱାମୀ ନଥିଲା ବେଳେ, ମାନେ ଆଜି ସକାଳେ ତାର ସ୍ୱାମୀ ନଥିଲା ବେଳେ ଘରେ ଥିବା ବିଷକୁ ଖାଇ ଦେଇଥିଲା ଏବଂ ତାକୁ ଗାଳି ଗ୍ରାମର ଭଦ୍ରଲୋକ
Petitioner is allegation against the petitioner also. After investigation, charge sheet has been filed.
My lord.
The perusal of the statement recorded by the police under 161 CRPC of the independent witnesses reveals that the present petitioner with the husband of the deceased have been repeatedly scolding the deceased for not giving attention to the study of their son. Study of their son. The petitioner has been blaming his wife that instead of concentrating on the study of their son, she has been wasting time by gossiping in the village, and out of rage, he has also asked his wife to die by consuming poison, consuming poisons. Now, on 19/1/2024, while the present petitioner was away from the house, his wife consumed poison. Immediately, the family members have taken her to hospital, but she could not be revived. She could not be revived. Therefore, the FIR was registered against the petitioner. He is in custody since 20/1/2024. Regard being head to the nature of acquisition and period of custody granted. Yes.
44.
Net legal action.
Yes.
Not initial custody number 2024. 2024 number and offense number 21B number and quantity number 109 gram of brown sugar melon.
Brown sugar.
Antecedent melon. Petitioner is a local man.
Yes.
Yes, sir.
She is there. 109 gram. 109 gram brown sugar. Custody 29/4/2024. Subject to verification. Yes.
45.
I pleasure also. Three bail applications are there. 6047. As per the first bail application is there. I was permitted to
First one, first one, huh?
and second
That is 6047.
6047.
Withdraw.
6047 withdraw. And as per the two bail application, I pray for next week.
Okay. Urgent. On request urgent. Yes. First one withdrawn and the other two urgent. On request. Yes. 46.
46 and 49 are result of the same case, my lord.
Yes.
The present petition, they were apprehended on 14/2/2024.
She is there.
She is there. That is on last occasion, on last moment, the 46 and 49. 49 is
46 and 49.
49 तक भरपूर केस रे सेदिन आस्तेला लेट आसला बेला मु आर्जन कर देथिली.
Yes.
That is 73 kg and the present petition is the one of the occupant and driver.
You are one of the occupant
and driver.
Driver. You are driver.
My lord.
46 driver.
46 driver.
49
occupant driver.
Occupant. Recovery
73 kg.
73 kg.
Antecedent?
No accident, my lord. Lordship mechanic reflect.
Custody?
Custody 14/2/2024.
2024. Oh, yeah, 49 कर दिया. 49 and
46
and 49. 46 is the driver of the vehicle and 49 is the occupant of the vehicle. ठीक है? Subject to verification. Yes.
47.
No antecedent, huh? Yes.
302, my lord, here, except the confession of the present accused, there is no other material. No witnesses are there, no incriminating material is there, no motive is there. She continues to this is the confession of the accused before police. Custody since 11/5/2023.
Yes. Yes. What are the materials except confessional statement?
And charge sheet already filed. मैंने सिर्फ देखी नहीं ये वो ये कौन सी है कौन सा बॉक्सिंग के बारे में डाले
13/5/2023 तारिख दिन जयपुर सदर थाना एएससी साहब को मोर बयान लिखी जे
समय जानो तो 15 वर्ष अक्सर
रात्र 11 घटिका समय मु एवं आम ग्रामर दम्बुका दबा पिता मुख्य कृष्ण दबा लालू हरिजन पिता धनपति हरिजन वर्ण कुमार परिजा पिता धनपति परिजा आम ग्रामर त्रिलोचन मिश्र को बंध थिबा घर
15 वर्ष वर्कशॉप करथुलु सेही जण
होइतले एवं मते मध्ये डाकतिले किंतु मु सेमानक सह जीवाक मना केली तापर डंबुलर वन विभाग से थिबा नदी बंध पे जीवा पई बाहरिले एवं
राम घर को चली गए
तापर जो
last scene. What else?
They were discussing. That means after death, later morning, he heard that he has been died.
No, that's right. But any other circumstances? Any other circumstances?
Circumstances then 27 and he that stone on which he has beaten him, that stone has been recovered by.
On 27, the stone was recovered.
Stone was recovered.
Yes.
No motive, nothing.
No, madam. No, दूसरा point नहीं किया
When he shoulder me, it is sudden progression.
Sudden. Who is that, this witness?
This witness is
Witness?
Harihara Mudali.
Harihar Mudali. What is the stage now?
ବର୍ଷେ ଉପରେ ରହିଲାଣି ଚାର୍ଜସିଟ୍ ହେଇଯାଇଛି ଆଉ
No, what is the stage of the trial? Stage of the trial.
ଆକ୍ସିଡେଣ୍ଟ ବି ନାହିଁ ଆଜ୍ଞା କମିଟମେଣ୍ଟ ହେଇଯାଇଛି
Commitment.
କମିଟମେଣ୍ଟ ହେଇଗଲାଣି
Stage of the trial, you tell me. Stage of the trial, you tell me. Shall I pass it over or?
Lordship here, charging on 30th June 2024. Rejection in 1960-2020.
5-6 ଦିନ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି ଆଉ
Right. Either Harihar Mudali should be examined or you remove your bail plea. Let Harihar Mudali be examined. That's a better idea.
That man, Harihar Mudali,
As a first witness.
the Harihar Mudali, if my lordship will go to the other statements of the family members of the deceased, they have stated that जे आमको घरे कोई गला जे मैं जाते नहीं हो गए
No, the incident is they were sitting together.
Yes.
All of them went, and in between there was a couple the scolding. Out of the fit of rage, they killed him. That's very.
lordship may grant me liberty to remain here after examination of this Harihar Mudali.
Right now. The petitioner is agreed by the order dated 19/6/2024. Subsequent thereto, charging when charge sheet was there?
My charge sheet submitted on
2024.
36 2023. 23 रे charge sheet है 24.
No.
36 2023.
Right, bail plea has been rejected. Right, bail plea has been. The charge sheet has already been filed in the present case. There are there is no direct evidence against the petitioner. However, one Harihar Mudali.
Harihar Mudali, lordship में
Who
so charge sheet witness option है वो कितनी दी जाएगी?
statement was recorded by the police under section 161 C.
Harihar Mudali मतलब CSW 6 charge sheet witness 6.
He stated that he had seen the present accused and along with the deceased last week on 13/5/2024 night. 23 night, and subsequently on subsequent day the dead body of the deceased was found. There are certain incriminating evidences, circumstantial evidence which has came in record. I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the recording of
Harihar Mudali,
who is
charge sheet witness number 6.
cited as witness number 6. Witness number 6. But trial court is directed to do well to see that the said witness is examined as a first witness. First witness by giving preference over all other witnesses. With this liberty, the petitioner is
May I please ask, my lord, this of already mentioned not amounting to modern millards. Petition is the first offender having no CO, my lords. Posted date millards 27/4/2024.
Yes.
And charge sheet offenses 304 IPC section 135 of Electricity Act. Allegation is that the informer's husband had gone to the agricultural field to irrigate the crops millards. And he came in contact with live electric wire that was a lead millards. And allegation is that the petitioner had loaded that wire millards to prevent those animals millards. And the villagers are saying that I had done this to pray, to hunt the wild animals. But fact remains the petitioner has no CA of any nature millards, including under Wildlife Protection Act millards. Custody nearly 304. 304.
See.
This is the admitted fact. See, he has laid down the wire.
Yes.
Electricity, open wire.
Yes.
She custody since
Custody 27/4/2024.
27?
4/2024.
24.
27/4/2024, my lords. And no CA any nature.
These are the admitted facts.
Objection for 624.
ये offense रा कौन?
हाँ.
627.
304 offense रा. Nearly about 6 months inside. Ella appear before the police station.
Person is died in the accident also person dies. Negligence, but motor vehicle accident, these are bailable offences. Rasan negligence, even if somebody dies, then bail is granted. But see,
Ella appear before the police station.
what are you, by the way?
My lords.
What are you doing?
My lords, I am farmer, my lords.
Granting it, right off. Petitioner is accusing so and so. This allegation against the petitioner is so and so. These are the admitted, the evidence which has come on record in the form of the charge sheet reveals that the petitioner has deliberately laid the electricity wire across the boundary.
Across the agricultural field.
Across the agricultural field. Agriculture field. He accidentally got electrocuted.
Yes.
Got electrocuted because of the negligence, because of the deliberate negligent, deliberate act of the petitioner. Deliberate act of the petitioner. The land counsel for the petitioner submits that the petitioner has laid the electricity wire in the field only to ensure that the wild animals
are
not destroy the crops. He had no intention to hurt anyone. He doesn't have any antecedent. Much less antecedent relatable to wildlife. The wildlife, what is that?
Wildlife Protection Act.
Wildlife Protection Act. The petitioner is already in custody from 27/4/2024. Charge sheet has been filed for alleged offence under section 304 IPC.
Section 135 let's it.
130?
135 let's it.
What is the sentence there? 135?
3 years.
Regard being had to the period of custody and nature of acquisition. Inclined to enlarge the petition on the
Again, that's something she will do. That's protest
वो condition लिखिदवा shall not repeat similar kind of offense, and if he is found wanting in violation of any of the conditions, even for once, the concession of being granted by this court shall be recalled. Sarla?
Item 91. What I was mentioning, item 91.
Yes, sir.
Can we have it on 23rd, 24th, 25th, my lord, any date convenient to your lordships?
91, what is that?
Lord, this is a FIR based on a second FIR file. And your lordships of the last order had said that investigation will go on and they'll report to your lordships about closure of the FIR.
Okay.
23rd, 24th, 25th, my lord, any day at 2 p.m.
25th.
My lord, 25th. Grateful.
25th.
Lordship I said 2 p.m.
To continue at 2 p.m. Yes.
Grateful.
Yes.
Yes,
very good. After the case.
Because pilot, I have separate deposition copies, but I have verified the record pilots. One eyewitness, Sitaram Dhale, is not been examined.
You give this deposition to right now.
The date was fixed on 21 minutes. That will be
fixed it. Yes?
Yes.
Move an application and look into it. Yes.
Obliged.
Yes.
51.
So therefore, you will matter.
Bail matter.
Why are you asking adjournment? It's so difficult to get it listed.
No, no.
And once it is listed, you are asking for
argument. So they could not produce the CD. So your lordship keep it to next.
Well, I have given the instruction anybody who is asking for time in a bail matter, list it in November. It's very difficult to address the board, you know. Once it is listed,
They wanted to take instruction. No fault of mine. Why should I suffer, my lord?
anyway, this may be this thing. Remove application.
Yes, ma'am.
Yes.
Obliged.
Yes.
My lord, 51.
Yes.
Your lordship may kindly turn to Annexure 3. Your
Annexure?
Annexure 3, page 30.
Okay. You are in custody since?
My lord, custody since 9/7/23.
9/7/23.
Out of 38 witnesses,
Yes.
by the time I have filed the bail application, 3 were examined, and in the meantime, another 4 or 5, about 8 witnesses examined. And I have granted twice interim bail, and I surrender in time. That has been reflected in the lordship's order also, Annexure 3. So, my lord, I am in custody since one.
But see, since entering bail, you got, when you surrender, that doesn't.
And I don't have any criminal antecedents.
That's right, but the recovery is received.
My lord, recovery is about 60.
420.
No, my lord, you may kindly turn to page 31.
31.
Yes.
Yes. Yes, 31.
Lastly, the recovery is about 60 kg, 400 grams, because about 4.
And you say 30 kg because you divide that
60 kg, 60 kg, because, my lord, there were 4 different motorcycles. It was.
What did it say?
Some of the witnesses examined.
8 witnesses have been examined. I am making.
How many witnesses are there?
38.
32 witnesses. All the materials are
And, no, my lord, your lordship, I am having the woman,
Yes.
that is, I have also annexed.
Yes.
The woman. Yes. Nice. Yes, my lord.
Let the material witnesses be examined.
Your lordship, kindly turn to page 28.
20.
28. 28. Nothing was weighed in my presence and in my weighing machine. That is one. And in the meantime, the other witnesses have been examined. Your lordship, kindly, I am having the certified copy. My lord, in cross-examination, paragraph 9, the seized articles are kept near the road.
Para?
My lord, I am having the certified copy. In the meantime, they have been examined. PW6, paragraph 9.
Yes, I read it. Regarding the genuineness of the machine and no authenticity was verified, and I have not mentioned the name of the person who prepared the notice and all. These are very small. Let the material witness be examined. 420 kilo.
You of your lordship's own order. I
am entitled to commit mistake.
No. That
I can't repeat that.
We cannot do say so.
Wait till the material witnesses are.
Your lordship may keep it to after vacation.
I'll put it on November. Let us see.
November, my lord.
After vacation, I don't think the material witnesses could be examined by the time because it's holidays.
30 witnesses are to be examined.
Immediately after vacation, 1 week thereafter, simply examined.
Obliged.
And all the witnesses, those who have been examined in the meantime, place it on record. Yes. Yes.
52.
Yes.
52, your lordships, is the CBI matter. I think SAR has recovered from dengue. Your lordships,
Are you making some personal comment?
No. So your lordship may kindly come to.
Yes, I'm recovered. Yes, I know. I recovered from dengue. So in the beginning only, if you raise the.
No, it was good to read. This is no personal comment. It was good to see sir healthy.
We only say that you recovered from the dengue.
I have not said when he had taken the date, the last date of hearing. When I was compared. All right, let us.
The
Yeah, please.
Yes.
This accused,
This matter.
Your Lordship, Your Lordship, this accused is constantly threatening the IO,
Okay.
constantly threatening the witnesses.
That matter where the IO, I asked the CBI IO to appear in the court.
Yes, sir. Cannot-
Yes.
Lordship, allow me to read that statement once again.
Yes.
You cannot do anything even if I do not do appear before you. I know how to manage the courts, High Court. If you report anything against me, I will also make false complaint against you, like I did before.
I'll tell you, Mr. Naik, I'll tell you, this kind of sentences are being uttered by the lawyer every day.
Now, Your Lordships, has given a complaint. I have filed a fresh affidavit, Your Lordships.
Therefore, people say that the judge is being sold every minute.
No, Your Lordships, Your Lordship may look at his conduct. Your Lordships, I filed a fresh affidavit, Your Lordships.
I have interacted with the IO of the case.
Yes.
The conduct is not acceptable. I agree with you. We can't.
Your Lordship, the witness has given a complaint. Lordship, may kindly read it. I cannot use that language in open court.
Yes.
Lordship, may kindly see the affidavit.
Yes.
Dated 20th August, filed by me, Your Lordships. Lordship, may kindly come to last page where the witness in this case.
Last page of your reply.
Last page of my fresh affidavit, Your Lordships, which I filed.
Okay.
Which was filed on 22/8/2024, Your Lordships. Sir has a copy. Last page, Your Lordships, I would like to read the complaint given by the witness to CBI, Your Lordships. I don't want to use that language, Your Lordships. अरे डैश सीबीआई मोर कौन करिवो मु 5 कोटी देबा बेल आछि and asked me to withdraw the complaint which I made to the CBI such and such, and when I denied that,
I'm wondering why have you not raised a case against him?
Your Lordships,
Yes.
Your Lordship, that case.
See, what I'll do is I have seen it. The allegations are very serious. The manner in which this accused has conducted is also not acceptable to the court.
And also, Your Lordships, one more, Your Lordships will kindly see their counter affidavit. They have filed a false affidavit, Your Lordships. Last date of hearing, Your Lordships asked them. Your Lordship, kindly read their counter.
Let us not stress.
No, Your Lordships, they have stated that. Your Lordship, they have stated.
What I'm proposing, I'm not cancelling it. I'll impose cost and the utterances which he has made and the manner in which he has conducted himself, registered a case against him.
Your Lordship, direct it.
I'm giving you liberty.
Yes, Your Lordships.
See, your conduct is, I'll not cancel the bail. I'm sure about it.
But I'm coming on the second part, my lord. Yes, sir. Kindly see the two annexures. All the case is on the basis of three things. First, as my lord has indicated, that my non-cooperation towards investigation. Second, my misbehavior with the landed investigating officer. And third, the witness complaint, 3 points he has indicated. And entire petition, there were 3 points.
No, Your Lordship.
Example, my witness complaint.
Yes.
He is annexure 5.
Yes.
Page number, my lord, is not in my annexure 5.
Yes.
Allow me to read, my lord.
Yes.
With humble request, it is indicated to Superintendent of Police, EO such and such matter. With humble request, I, Sri Sudhanshu Sekhar Patnaik, while I was going towards Kandagiri on 1st of
Sudhanshu is
yes, they are saying it is witness. It is not in my knowledge, my lord.
Yes.
When I was crossing Syria,
I accidentally met Vikas Swine. Vikas Swine is you.
Yes.
Yes.
I accidentally met Vikas Swine in front of CBI office at around 11:10 p.m. Suddenly, he started shouting at me and used slang language such and such and asked me to withdraw the complaint which I made to CBI on 13th of June 2017. In the entire document, I didn't find this particular original complaint, which he made in 13th June 2017. And after passing a 4 year, this complaint is going to be forwarded to the police.
This was
Incident to 4 years ago.
2017.
Yes. They have made a criminal complaint. That complaint is not here. And this is not giving any signature, any date. I think it is antedated. And why it is done, I will come on the permanent. I denied that.
And it was forwarded on 3rd of 1st of
Yes, yes, sir. And
March.
can we see
21. Yes.
page number 41.
Yes.
With humble request, I see same thing is repeated.
Yes.
So what happened, my lord? Yes, what is saying that incident was 5th of June 2017.
See, there are claims and counter claims. Let it be investigated.
Yes, your lordships.
Or if there is a judgment also, if there is a counter claim and claim, that we will leave on the trial court. I'm not on that. If there is a claim and counter claim, but what am I saying?
Trial in this case, it is nothing. See, it is threatening the witnesses, threatening the scandalizing the court. All these things, allegations are there. It is independent, the cause of action to be investigated by the authority. Why should I get into all?
Why the IO?
I can't go into whether it is correct or not. Why? See, I can see 2017 is the incident,
yes,
and 2021 it is forwarded.
Yes, sir.
For what reason? What reason it was not done? Because I didn't gone into. Let it be gone into lordships.
Presentation to the CBI director, alleging that investigation was not being unfulfilled.
Where is your
yes, my lord.
complaint given to the director?
Yes, my lord.
CBI
I will see
director.
my reply.
Yes. Where is that?
Page number 73, Annexure 7, my lord.
7, Annexure
Yes.
7.
Can you see? I have dared to put and demand the justice.
That was in February 2021.
And they have also, after that, they started doing this.
You say it is March, 1st March.
Not 1st March. And then I file an SLP in next in this document. And started happening. And one more two legal thing, my lord.
Yes.
Kindly see my preliminary objection in the court reply.
Yes.
I have filed an application in the court for waiving of one of the conditions that I should not appear, bound to be appear every Monday.
Yes.
During that, my lord, my CBI has objected that yes, they should not get that thing. And the Honorable Court has said that let the board the petition listed together. This petition and my petition for waiving of the condition. He has countered my argument there. Court has passed the order. Kindly see my supplementary agreement or supplementary affidavit, my lord.
Is that? Yes. Yes.
Page number 4, Annexure R1, my lord.
R1.
R1.
Okay.
This is order is 16th of March 2023.
Yes.
I will read, my lord, the page number 2, middle para.
Yes.
Mr. Karthik Nayak, learned special public prosecutor, on instruction submitted that further investigation is under progress and more amount has been surfaced in the meantime during such investigation and further submitted that such prayer was also made in the possession of.
How many cases are?
I have only one case. One case, my lord, and one small one para allegation that I have received money of 1.48 crore against the advertisement and I failed to give the receipt. Newspaper, my lord. Cancellation of bail, White Criminal Amendment number 94/2021.
Yes.
In view of such submission, my lord, put up this matter along with criminal miscellaneous number 94/2000 on 30th March 2023. London Council for CBI shall obtain instruction as to whether the investigation has been completed in the meantime or not, whether the petition has been complied with the condition.
Yeah.
Next, kindly see page number 7.
Yes,
This is the list.
there. This is the list.
Yes.
Both
reflecting that both matter heard together. And after that, my lord, this is final order 6/4/2023, where that condition has been waived off. So, whatever the argument that has been considered by one court.
Oh, your lordships, arguments were not considered.
Mr. Safra, please don't interfere in the matter. Just I'm assisting the court.
No, I'm just adding, I'm not interfering. I'm just supplementing. No, don't take it as interference.
Then appearing on every Monday, the court said that agent when required. That is not
Yes.
And since then, I didn't get a single summon. And with the order of my lord, I appeared first. And the second time, after just after the same liberty, my lord has said, no, when you will call, you go. And as and when called, you go, and it means I am not required for the investigation. They were only harassing me when my wife was.
I am not cancelling your bail. I am making it very clear. But I will never cancel a bail once exercised by the discretion of any court. But the conduct has to be gone into.
That's what I'm saying.
Just taking the application of the CBI.
My issue is different.
And whatever allegations are there, that has to be gone into independent.
Yes, your lordships.
That is what I'm saying. I am not.
Yes.
That's I'm grateful. See, cancellation of bail is ruled, but the allegations are serious, so you proceed in accordance with law.
Yes, your lordships.
It is open. I will give you admiralty.
Yes, your lordships.
It will be open to him to proceed according with law. So then that one.
No, let a direction be given, your lordship.
I'm just requesting, don't ration my will be given because it will be.
Have you seen in any criminal jurisprudence a direction is made to raise he has a liberty, I give that liberty. I'll tell you why.
Yes, madam.
Then otherwise, see, you are saying that the court right in 2017.
Yes.
And there may be a limitation under 468 and all this, therefore liberty has to be granted.
Madam, how can I do that? Therefore, if my wife was suffering from cancer, you are being operated. In
Lordship,
come and do like this, madam, what he is saying. It is bad.
Lordship may kindly come to.
The IO is a senior officer himself appeared in court. Why should it come?
What are you doing from last 17 years?
And then let it be gone into.
On the cost, how can I?
Your lordship, 2 points. Your lordship, may allow me 2 points. Sir has, by mistake, sir has left 2 points. Your lordship's paragraph 3 of the reply for a moment. In paragraph 3, your lordships, they have stated that all facts. Your lordship, 1 minute.
How much you want to argue?
No, after cancellation of bail also, your lordships, they have stated that I filed a reply to the modification application. No reply has been filed, your lordships. How can they lie before court? All the facts and circumstances leading to this application which prays for cancellation were raised in the counter reply in the said modification application. There is no reply, your lordships.
Therefore, I am giving you liberty to proceed against them. Against
Yes,
you.
your lordships. Yes.
I'll pass the order. I'll pass the order. Next. Please. I'll pass the order. It should be a balancing act. It's not that.
File a complaint case or whatever you have to.
Whatever they want to do, they will do it. They have all the right to do it.
Yes.
But see, because the matter was going on, if they would have succeeded in the cancellation of bail, perhaps it would have been matched the expectation. Since I am not cancelling, the allegation has to be gone into.
Yes,
by an independent.
Different.
I'm not going whether right or wrong.
Yes. That is the judgment of Supreme Court also, my lord.
Yes. That's what I am saying.
Many judgments, my lord, for this.
Not required. Yes.
Great tool.
Yes.
Please, lordship.
May I please, your lordship?
That's why cost moving to the bar association. That my trade is why you go back in the
He is going to contest next time, Vishwanath.
But this is an application for cancellation of bail.
You heard what I said. I am not going to cancel. You tell me what cost I should.
Earlier, the opening was arrested on the strength of
when you got the bail? Got the bail?
24/5/2023.
23 got the bail.
After the legal bail, the opening number 2 accused has been threatening the victim guard.
Yes.
And he will making her naked for that. Very much on social media.
Preferably after bail.
After release and bail. So naturally can see the annexed 4 bail.
Except 4.
Annexed 4.
Yes.
She was lodged on an FIR at Cyber Police Station at Kotak.
FIR is already registered?
Registered, but no action has been taken in that now.
Just check it up. It's a FOXO case. Bail has been granted. Thereafter, again, after bail, and he is trying to viral the new photograph and all. If that's the case, then it is notice to opposite party number 2 written after Indian. Yes. Next.
55.
Within 2. Yes. Next.
55.
55. Yes.
Well, that matter regarding the 6 minutes.
Completed.
Let's see out of the confidential credits, right?
Is out of the country.
Well, it's the son and daughter in law minutes to have lost the affair minutes. It was the old parents minutes. That's
Washing of the affair.
No, that's.
Matrimonial.
In the meantime, Sachin has already solved. Sachin already solved.
You are the father-in-law, mother-in-law.
My lords.
What to do? See the informant. The daughter-in-law.
Husband also when evidence, the statement of the son of the petitioners, they have the categorical sons that this two petitioners they are already actually
Daughter-in-law is now staying in overseas. Why to put these old people into trouble? Is there any stay? Stay?
Unless order was there, my lords.
Stay of further proceeding. Absolutely correct. Non-appeals despite service. On a service is not complete, no? On the first address furnished by the petitioner, attempts were made to serve party number 2. However, the report reveals that the opposite party number 2 has left the country. Do you have address?
My brother, no, we don't have my address.
Let the country. Yeah. Oh, IIC.
But the thing is that, my lords, the other son is staying at abroad. Now they are not getting any visa, nothing, because
let the stay continue, let it be pending. See, these people are 73 and 63. They are mother-in-law, father-in-law. And these people, the informant is also there in abroad. Let it be stay.
But my lords, they are not able to go to other son, my lords. He is staying, other son is staying at US, my lords. They are not able to go to him, my lords, because visa.
Is there any condition for going abroad? There is no condition for the being that way.
My lords, they are not getting the visa, my lords, because the case is pending. That's it.
Yes. Next.
56.
56, my lord, we are appearing for opposite party number 2.
Please, Manoj.
Yes. Yes, sir.
This is a petition for quashing of FIR, Manoj.
Yes.
Initially, the FIR was registered under section 376, 493 and 417, Manoj. Subsequently, in the charge sheet, 376 is removed. Only 417 and 493 is there, Manoj.
Yes.
I'll just go into the allegations in brief, Manoj. While the petitioner was OIC in Khunta PS, 1994 minutes, this victim came to PS to seek help in a domestic violence case against her husband. According to her allegations,
Here, also notice not a
Sufficient. Yes.
According to our allegations, my lord, from 1994 to 2020, he kept physical relation with the victim, my lord.
You
Petitioner, yes, my lord. That
you
was
were the investigating officer in one of the matters.
My lord.
Where she was the complainant.
Complainant, right.
Okay.
So, from 1994 to 2020, my lord, it is alleged that I was, wherever I was getting posted, I was posted between 8 to 9 locations in that period, my lord. I took advantage of
she has been going and you have been keeping going.
Now, interestingly, my lord, both the offences are non-cognizable. In this charge sheet is filed. A charge sheet cannot be filed, my lord, as per section 2D of the CRPC, my lord. It should be treated as a complaint case, my lord. And the police officers shall be deemed to be a complainant, my lord. Another thing, my lord, cognizance has also been taken, my lord, in this thing. Page number 60, annexure 5.
Yes. Page number?
60, my lord.
16.
No, 60, 60.
60, okay.
Last page.
Yes. Yes.
According to the, my lord,
cognizance taken for 417, 493.
I would like to come to the antecedent of the victim.
You just forget about antecedent. If the case is made out. I am not here to go into all this thing.
Someone's conduct has
493 is there.
Yes, my lord.
You are married.
I understood.
Then-
I
then-
just want to show one annexure.
Why you pitch the case to that level?
No, no, my
The charge sheet was wrong.
It is even believable that someone is taking
So believable or not, that will be decided in trial. The cognizance stage, you tell me. Why should I cause the cognizance of? Elements are there, wrong, right, whatever. Determine in the trial only.
I just want to show the conduct.
Conduct, I am not going to show. Conduct maybe. I can't do that. On the basis of the conduct of the informant, can the FIR be quashed after charge sheet is filed, cognizance is taken? Answer is no. Answer is no. Better you withdraw or raise all the points at the appropriate. Land counsel for the petitioner seeks to withdraw the petition.
May I please your lordship?
Why if I don't entertain? Raise all the points before the trial court at the appropriate stage with this liberty, the petition is disposed of. Next.
57.
Yes. Yes, sir. Service.
Back. Not delivered.
Not delivered. Notice is not delivered on opposite party number 2, right? Give and counsel for the petitioner
Awaiting service.
awaiting service. Or service awaiting. Service on respondent number 2 is awaited. Please the matter after. Yes, next.
Proceeding for stay or proceeding to there.
Service is awaited. How can I stay like this? Yes, next.
58.
Made to the lordship.
Yes.
Your lordships, last week the lordship directed to file an additional affidavit to it 311 petition. I have not filed your lordships.
Not filed.
No, I filed. I have filed. Earlier, I have not filed your lordships.
Yes.
In fact, your lordships, 311 petition has been rejected.
311.
311. Yes. 311 petition is using. My prayer was.
Yes.
Let them serve a capital. Your lordships, PW, in fact, prayer confined to lordships 17, 18, 19.
17?
17, 18, 19.
Yes.
Your lordships, I have filed the petition without any question, without framing any question. Without framing any question.
There must be a change of counsel. Now I want your counsel.
No, lordships. It was before, at court of your lordships. Case has been transferred to Dhankana. It was conducted.
Again, same thing. Now my things that once again.
Decline on inferences, lordships. That is more difficult, your lordships.
17, 18?
17 and 18, 19. I have only prior lordship 3 instructions.
Decline cross examination. I give one opportunity, finish it up.
It's one more date, your lordship.
See, decline examination by
served as a copy just now. I have been served.
Finish it up. One opportunity and no further examination.
Yes, lordships.
At 17,
17, 18, 19, lords.
17, 18,
and 19. Can it be taken up tomorrow?
Tomorrow.
Yes.
Tomorrow.
Let him serve a copy also.
Tomorrow.
Let him serve a copy.
See, 17, 18. See, I'll tell you, 17, 18, decline cross examination. He moved the application to 311 without proposed questions.
Yes.
And now he is an accused, he is an indefensible right to defend himself.
Yes.
And the questionnaires he will give it, he furnished to the court and court will give the and one opportunity tomorrow.
Or Monday, Monday. Monday is not a last one.
Monday because
Monday.
tomorrow.
Monday.
I'll not forget, don't worry. Monday.
Yes.
So yes.
Let us have a copy.
50?
59 59.
Yes. Your lordship heard this matter at length. This is a case first come to case 18. 18 of my brief. Towards last. Initially, FIR was lodged by the complainant.
Yeah.
Stating that in the investigation reports.
What are you asking here?
Yes. And thereafter, in this case, there is no height of evidence. I'm placing 1 second I am placing. Last time, your lordship directed
After 3 years, again complaint case.
Oh, 311. Yes.
211. Because of evidence they have.
Thereafter the complaint files, not protest petition.
Not protest, sir. Yes, sir. Yes.
Now you see the funniest thing is FIR was registered, investigation completed, a closure report was filed, and the IO says that completely false case. He should be proceeded under section 211. And instead of filing protest petition, what he does is he wait for 6 months or something.
3 years.
3 years. They have to file a complaint case. And complaint is taken. But it's the same case.
Since alleged complaints, they made the complaint party notice it.
You have not served the notice.
Because I have to get them directed to the state council to verify the complaint petition. I have.
But the notice has to go. Issue notice to opposite party number 2. I say the proceeding. This is the case where right now petitioner is assailing the prosecution launched against him by opposite party number 2 in CC case number 1 CC case number 3 of 2021. So initially the petitioner, the informant opposite party number 2 had filed an FIR being Motanga case number 2018. After investigation, in that case, the closure report was filed by the police inter alia stating as under last paragraph.
In this case, there is no item in this case.
The complainant, informant, instead of resorting to the normal procedure of filing a protest petition, preferred to file a separate complaint petition after the lapse of 3 years.
3 years.
3 years. And in the same complaint case, cognizance has been taken. Issue notice to opposite party number 2, returnable and so and so. In the meantime, proceeding in CC so and so case, it's state. Yes. Next.
60.
Yes.
Chair have filed an IE for inadvertent criminals. The court name has been typed as JMFC Nagar. It has to be
modification of which order?
That's your lordship.
28.
JMFC Nagar has been stated. It has to be SDGM Nagar.
SDGM allowed.
I'll file consolidated petition. The matter is sub judice.
JMFC category in order dated 28/8/2024.
Also in the cost title and in the body of the petition.
Yes.
I'll file the consolidated petition.
Yes.
61.
61.
Yes.
Yes.
Here I have filed for contemporaneous hearing of both the cases, which are cases of similar incident. If your lordship will see, the petition for contemporaneous hearing at annexure 1 was rejected.
Yes.
Wherein your lordship had pleased to issue notice and grant me.
You see the service.
What happened in this case, coordinate based on 21st to 24 matter. Directly state court obtained instruction regarding status of counter case matter.
Yes.
But what happened in this case, though the IO matter sent the instruction, but in fact, he has stated that both the cases are sub judice. In case of the present case, the case has been awaited against one of the actually one there are 4 to 5 active person, one active person. In fact, he has not given detail of the about the status. I contacted the IO today morning. He assured me
Pursuant to the order dated 24/7/2024, the IO of the present case has not furnished appropriate instruction to the State Council. Hence, Mr. Ragada seeks a 1 week adjournment to obtain appropriate instruction. Please the matter so and so interim order to continue. Yes.
That's grateful.
Yes.
Lord, I am for the informant matter. The counsel for the petitioner, his father expired on Monday matter. But let it come.
Informed that there is a bereavement in the family of the counsel for the petitioner. Hence, the matter is reach the matter. Yes.
Well, my name may be reflected in the
name of the counsel. Yes. 63. Vigilance case.
64 now.
See, this is another case where entry order is operating since long, it seems.
That's maybe kind of pass over like this. Mr. Mara will be living in this country.
No, there is no entry order, this is criminality.
Then your lordship,
Criminality, weekly list. Yes.
64.
Yes, your lordship, I handed over these two documents last occasion. Your lordship had marked it.
Yes.
The account which is connected to the demat account that positive inspections. Lordship, I kindly see.
Yes, see.
And if these things can be safeguarded by lordship's kind direction, then this can be disposed of.
Yes. Inviting reference to the ultimate objection the release of the present value of two domain account.
Yes, ma'am.
And deposit the said amount in corresponding savings account of Axis Bank.
Yes.
And to keep the said amount in the fixed and to keep the said fixed deposit in the Warren court. Have you seen the instruction? Let's see.
Yes, it has not been shared with me.
You have.
No, if you actually read it, I heard it, madam.
And what they say is that there are four instructions, this thing. First of all, if release of the present value of the two demat account, no problem. Deposit of the said amount in corresponding savings bank account in Axis Bank,
yes,
no problem. To keep the said amount in a fixed deposit.
Yes.
Okay. To be said fixed deposit in the London court.
London court below. This was the specific. This was the specific clear in the criminal appeals department. I am allowed it. Yes, ma'am. I am allowed it. All these things can be surveilled.
I know.
I am extremely grateful to my friend.
That's what I was saying. It is sorted out. Easily sorted out.
We are here to find solution to the problem. That's the kind intervention.
In any case, what we do is in 457 cases, Mr. Das has been getting information and that pass the order. That's the best.
Plus one more observation on this.
Yes.
The applicant should not have the transactional rights. It should be kept into feasible in the court below. It should not.
He will be operating the demat account. That's what his case is.
Unless until I operate my lawyer, there is no point.
Whatever is there, the value will be transferred to the savings account. No problem. But he wants a permission to operate the demat account.
Unless only my submission will be restrain any transaction of the said value amount. The last line in lordship can is. But the
transaction in so far as the amount which is allowed there.
Yes. But after the fixed deposit has been done, thereafter she should not be having any transactional rights.
Obviously, yes, that's the fixed deposit. That
comes on the basis of sale, my lord. That sale proceed will be intimated to the court. And then that will be converted to sale, brother. Yes. And that particular amount will be fixed deposit. Yes. And that fixed deposit fee will be deposited before the court. Regularly, it will be sale purchase. If I do not sell, my lord,
obviously. Right up. Pursuant to the order dated, where is that order dated?
Lordship, can you tell us the last
where I have given direction to hearing? There is specific direction to that effect.
On at last Thursday. And so far as those two deposit the said amount in the corresponding savings bank account of Axis Bank, and memo on 10/9/2024 indicating the account number, account numbers. That is important. You'll also also mark it very big. That is that memo that has been filed by senior on 10/9/2024. It is on record.
Yes. I have not passed in detailed order them. Only transcribed in the court already.
Yes.
I have not passed it.
And if those two account numbers may kindly be indicated in the order.
Which this number?
No, it's that memo that has been filed by my senior on 10/9/2024, indicating the is connected to the This is saving account. Is it the same number? Yes. No, this is a different number. It has not been frozen. The accounts which are furnished, these have not been frozen by the vigilance. That account has been frozen by the vigilance. My only submission corresponding to the same Axis Bank account that has been furnished by a level senior.
That's not the Axis Bank.
That's with memo number, memo dated 10/9/20. Same. It's the same number, then I don't have any issues.
It is not a beneficial. I don't. Petitioner is agreed by, better that I will make sure that
Yes,
easier. Right on. Petitioner is agreed by the order dated 11/7/2023, whereby passed by the authorized officer special court Bhubaneswar in confiscation case number 1 of 2014, whereby his prayer to release the demat account number UTO number UTO 10698,742. This is only one account.
and that's 100222469.
Both separate matters, but common order कर दो. ठीक है.
So these are petition
has been turned down. This matter is heard extensively.
Let's on can I notes this UTI account number corresponds to savings bank's account number so and so. We actually kindly have a look at this. This memo has been filed on LNC.
Which correspond to corresponding account number take दो.
One second. These two accounts have been frozen. The account which I have given, my lord, that is not frozen because it must go to an account.
I understand it.
Yes, sir.
But he says only the.
No, set eventually, sir. So now they have given the furnished the letter.
Axis Bank. These are not Axis Bank.
Yes, latest one are furnished, my lord.
Which are attached to the demat account लिख दो, तर attached account, corresponding account number. This is also Axis Bank.
Yes, my lords. But this is the account number which your lordship marked it with red.
Which one?
Yes, at the bottom, my lord. It's the same Axis Bank, my lord. These accounts have been frozen by the vigilance.
These are different account numbers. These are different
account.
Right.
Frozen, my lord. Which your lordship marked.
Yes. Only corresponding savings account and number so and so. Okay. So the said corresponding savings bank account number so and so has been frozen by the investigating frozen by the respondent. In this petition, the counsel for the petitioner seeks a direction from this court to release the demat account and allow him to operate the demat account. When the matter was heard extensively, the direction was made to the State Council to obtain instructions. I obtained instructions. Pursuant to the same, very of the instruction, Mr. Rizvi, through the memo, has filed obtained the instruction and placed it on record. The instruction reads as under. The instruction for the instruction reads as Mr. Sarma, legal counsel for the Mr. Sarma, Mr. Sarma, legal counsel for the petitioner, submits that pursuant to the instruction, he has no objection to the instruction, and accordingly he submits that the present matter can be disposed of on the basis of the instruction furnished by Mr. Rishi. Accordingly, the following directions are made.
The conclusion para your lordship may kindly see that same instruction which I was referring.
How would the Honorable Court may kindly
restrain from any transaction of the said value of the demat account?
Restrain from any transaction of the said value
of the demat account.
Except
said value.
Yes.
Whatever value is today is there.
Yes.
That value will be transferred to a fixed deposit. He will not transact that.
Yes.
And he will operate with the and whatever he will earn further, that also will be converted to fixed deposit.
Yes, no, that's what option.
Giving more confusion.
Yes, yes.
To the
Lots of undertaking I have given a lot. Option, can you observe that?
Following directions are made. The demat account number so, which are corresponding to the savings account so, is defreezed, and the petitioner is allowed to operate the demat account. The value of demat is on the date of date when it was frozen. Generate frozen when it was frozen. Date of freezing on such and such date shall be transferred to the Axis Bank accounts number.
Sir, 28/2003, sir.
28/2003 Axis Bank account number. You have to give the corresponding account number. I go check Axis Bank.
It is 15 at the bottom, like you also marking grading, charges bank account, saving bank account number, so on.
But which there are two matters.
One saving account. Account number same, bank same.
That account transfer to Axis Bank. Account number is red mark. Red mark option also. And from the savings account next, from the savings account, the amount will be converted to a fixed deposit. And the same shall be deposited before the authorized officer, Special Court Bhubaneswar, in the confiscation proceeding number 1 of 2014. 14. The petitioner is allowed to operate the demat account and trade allow the demat account, and whatever the earnings which would
whatever the value has been
generated value,
yes,
shall also be invested in the fixed deposit,
yes,
time to time, and the same shall be deposited before the authorized officer.
The generated money cannot be utilized any other except that. Yes.
As it is also made clear that the petitioner shall not be allowed to transact.
Yes, ma'am. Transact.
He said it will be deposited where it
cannot be utilized except fixed deposits. The amounts so generated may be utilized only for the purpose of fixed deposit.
Yes. The amount to be generated in the demat account pursuant to the trading,
yes,
to be undertaken by the petitioner shall be directly converted to the fixed deposit and shall be deposited before the before the authorized officer. And the petitioner shall not be allowed to utilize the money generated from the trading in whatever manner.
Yes, and
whatever
and to corporate matters and to corporate
what? What corporate? In confiscation proceeding, what corporate?
And corporate in creating saving.
Now, I mean, indicates something else. Corporation. You must know that. Yes, sir. Allow.
Grateful.
65. Yes.
Lots of item 65. This is a vigilance appeal.
Yes. 2024.
Lots of 24. I pray let a short date be given.
Post vacations months.
Post vacation.
Yes. Short date, my lord.
Yes.
66. May I pray the date may be full.
66. Yes. 66.
Item 65, we have Mr. Abbas Mani, the matter will be taken in any time post vacation.
Which one? 66. On request, Arjun.
67. 67. So far as one of the sub item 2 is concerned.
Collected items. The collected item 2012.
16.
Sub item 1. That's
2012. I will only file a memo for withdrawal. That memo may be withdrawn.
1621, you want to withdraw?
No, memo, I want to withdraw memo. I wrongly filed a memo for withdrawal of the main case. That memo will handle it.
Or even later.
Memo can be ignored. Memo taken up post petitions also. Item 67. On what?
Unfortunately, that memo has been filed in that case.
ठीक है, it's all right, ignore it.
Yes, yes. Questions.
Okay. Okay. On the request post petition, simply move to continue.
Post petition.
Yes.
May I please?
Well, everybody has come in vacation mood, it seems.
It's still for
My lord, here I am challenging the cognizance order which starts as page 21 and relevant portion is at page 22. My lord.
Yes.
There is sufficient material showing commissions under section 498A, 323, 506, 34 IPC and 4 DP Act. Hence, cognizance of offences taken, my lord. My lord, now I am challenging that mainly on the ground of compromise, your lordship may come to page 25.
20, you read out page number?
I read out page number 22.
22.
First paragraph itself.
Yes.
My lord.
There is the CD,
my lord, should I read it again?
Yes, yes.
My lord.
There is sufficient material.
My lord. So, cognizance of offence
498, 323 and all.
My lord.
Yes.
What, my lord?
What happened?
My lord, now that settled, I have filed the certified copy of the
you tell me, you bring them and to pass it.
My lord, the petitioner is available. That is what I wanted to apply. My lord, the petitioner is always ready and willing to appear. Your lordship may see twice notices have been issued and made sufficient on the wife. What has happened, my lord, in the meantime, they have both have married since last 10 years. This application is somehow
separately married.
Separately married and all are settled. Now, in the meantime, 9 years have passed after filing of this case, my lord. The divorce decree certified copy of which is before the lordship, there has been specific here that shall be compromise of all cases against each party. If your lordship
where is the service report?
My lord,
rather in this matter, this is same Vishwajit Manti.
My lord.
But in that, rather in this matter, you have been seeking time many times, just see.
So, my lord, what has happened? My lord, there I had not filed a certified copy of the order. And on all occasions, I have made endeavors to reach out to the wife. So, she has married somebody else, I am not able to trace. That's the case, my lord. But the ex-wife, who is the occupant of the
I understood it. But see, the coordinate bench on 13 January 2023 directed you that in view of the aforementioned submissions, let the petitioner and opposite party number 2 appear in person next week. Okay? Thereafter, again on 2/2/2023, you saw the time. Thereafter, again on 17/3/23, again you saw the time. And 17/4/2023, again time. And then 25/4 time. And 10/5/23, again time. 26/6/2024, again you have short time. Now you are telling all this.
I'll try to assist, my lord. Because there was an order, I was trying to
whether you have attempted to serve opposite party number 2 or not.
That is there on the.
There is nothing, because rather on the contrary, you have been seeking time.
See, 22/4/15 I have filed the requisites and it has been made sufficient. If that is not there, my lord, then. But now you have set up a nothing that there it is not sufficient. It is, I believe it is sufficient because I got it checked.
Rather, last occasion you didn't appear.
No,
before that again didn't appear.
I was unable to contact the petitioner because 10 years have passed.
I'll tell you what impression I got gathered from the proceeding is, you obtained an interim order?
No. That cannot be that. That is the impression from my understanding. That's not my intent.
You said that everything is settled. Okay, interim order, and then after seeking time.
Not having property, not to advantage.
You seek services. There is no clue.
I hope we may see 25/4/2015. I have filed the requisites already, and that has been issued. And If that is not there, then I will not submit anything more. 25/4/2015. Huh?
It starts from, it was there, 22.
Yes. No, मतलब 2015 स्टे है, 22 क्यों होगा? No, मतलब some probability also because the stay order is 2015.
That is the reason I am looking at. I got it. Now I got it here. 2015 stay is operating. And thereafter you have not appeared many times, not once, many times.
Not, I will not appear.
Yes, I have non-appear for the petitioner, non-appear for the petitioner. Like this. Entry models continue.
I have been seeking time alone because of that order to
You show me anything on record that you have made attempt to serve respondent number 2. What is the 2015 settle? If you say that what is settled,
if your lordship permits, I can see that.
Is there anything on record? Any attempt is made? Stay of notice issued to police party number 2 issue both ready. Postal address from so corporation service permission. Service report is not there. There is nothing. Nothing.
I am compliant. If your lordship
Petitioner is in this petition, petitioner is seeking quashing of for the criminal prosecution initiated against by opposite party number 2 on the ground that they have settled the dispute. Settled the dispute. They have the petitioner is the husband of opposite party number 2. Opposite party number 2. He submits that they have parted away, and both he as well as the opposite party number 2 have already settled in their life since last 10 years. Since last 10 years. This case, this present petition 2015 on 22/4/2015, the trial court proceeding has been stayed. Since from the record it is apparent that no sincere efforts were made by the petitioner to serve opposite party number 2. Rather on the contrary, the petitioner has been seeking time, seeking adjournment on the on many occasions. Petitioner have not even appeared in the court, and interim order is continued. By the last and final opportunity, the petitioner is afforded one more chance to serve the opposite party number 2. Opposite party number 2. The petitioner is directed to file requisite by tomorrow. Positively. Positively. In the event the petitioner fails to recover the fund, and it is the petitioner is also directed to give a extra copy of the petition to the state council, who in turn shall serve the opposite party number 2, the IIC, which police station? IIC?
Korangia PS.
Korangia PS case. PS. Korangia Moirvans. Leaves the matter immediately after vacation. It is made clear that no further adjournment shall be granted to the petitioner in any ground whatsoever. Yes.
What is this? 2015 taken. What is wrong with that? What I say? No, that I had filed in the meantime. Why have you not attempted to get the matter listed from 2015? It was being listed.
It is that I have given direction that wherever the state was listed, that thereafter this matter.
If there was an order directing me to file a certified copy of the divorce decree.
The semblance of any order. Do it now. And file the by tomorrow. Fail to do that. And give extra copies. Yes. If she will not come, I will pass it. In any case, this matter is pending since 2015. What case? End result is 0. Better you pass it and finish. Yes. Yes. Infectious. Okay. Infectious.
70.
All these matters are unnecessary pending.
That's actually a problem. I have expressed coming. I can still argue.
opposite party is appearing, he was noticed to appear also by.
If there would not have been a stay, your file would have been there with you.
Cannot escape.
See, 2.15 charges is pending.
It was there in last month or 2 months ago.
Now, what is this matter by the way?
Entire proceeding is in Calcutta. Parties are in dispute in Calcutta.
Is this matter still survives? Any cause of action to be heard?
नहीं sir, survive माना तो stay ही किया survive तो करिए. So what I am submitting, my lord, entire dispute is in Calcutta just because he received a notice, legal notice.
Where is your briefing counsel?
Sir,
where is your briefing counsel? You take the get the pen drive, take entire.
एक सर वीडियो है तो सिटी वीडियो.
Have you take it and get the pen drive and get it. And go into this thing, right? Mr. Santanu Shodagi, learned senior counsel, submits that he has lost the, he has misplaced the file and seeks an adjournment to reconstruct the same. Let him do so within a week. Release the matter immediately after vacation. First immediately. And these are old matters. Finish it up. Yes.
Entry model में कर दी.
Entry models country.
Your lordship may indicate that I will take care of.
I need not make part of it. I'm just telling you, you come and take it.
There will be like 84 items and items are wrongly taken each second item.
Leave your junior, correct. Yes.
But here I have challenged the order taking cognizance passed by the magistrate in taking cognizance offense under section 201 of the Indian Penal Code against the petitioner. Petitioner before my lord the doctor, government doctor.
How many accused are there?
But bereft of the present petitioner, others are police officials. What case is this?
No, what happened to the trial so far as the other accused are concerned?
I don't know.
Because this matter is pending since 2016.
Case is like this. Police officers, they have, I do not know. But here is the case where a X was arrested in connection with an offense. It is alleged that X was assaulted in the police station by the police officials.
No, the order is, as an interim measure, it is directed that the case, GR case number is ready for commitment to the court of session. Then the shall not commit the case for the petitioner. Committal is stayed.
With regards to the present petitioner.
So therefore, the
opted instruction.
So they might have been executed. If they executed or something, then we will benefit. I'll go ahead. By the order dated, petitioner is challenged the order dated.
Order was
order dated
8/12/2015,
whereby cognizance of offence under section 201 IPC has been taken against him. The matter is pending since 2016. On 18/1/2017, by way of an interim measure, this court directed the Sessions Court not to commit the case to the session qua the petitioner. And there are other accused persons. There are how many accused persons?
In fact, 4%.
There are 7%. There are
4%
7 accused persons.
there.
Ultimately prosecuted in the presidency. Since the committal proceeding, since there was a stay of the proceeding insofar as the present petition is concerned,
yes, sir.
The status of
7% independent petitioner.
Status of the trial insofar as the co-accused persons are concerned are not known to the petitioner. Hence, Mr. Dhal seeks 1 week time to obtain instruction. This is the matter immediately after the case. Okay. They might have been, I don't know, 2015.
I'll obtain instruction.
You also take instruction regarding the status of the trial. Insofar as the other. Yes,
Well, here is a case where I have asked you for quashing the yes, 1cc complaint and also the cognizance taken therein.
Yes.
The case is like this, madam. The complaint, in the complaint petition, the complainant has stated, the allegations, I'm just reading out the paragraph.
Yes.
At page 20, at page 30, 29 ending, 30, 29 end. That the complainant had to undertake traveling to Delhi in order to file his counter affidavit. 29. Okay. Yes, last paragraph. Yes, sir. That the complainant had to undertake traveling to Delhi in order to file the counter affidavit in the aforesaid case, and as such on 11/6/2013, the complainant filed the counter affidavit before the Honorable Apex Court and again on 1st July 13 appeared before the Honorable Apex Court. It is worth mentioning here that the complainant had categorically apprised the Honorable Supreme Court about the deliberate misrepresentation made by the accused number 1 in mentioning that the complainant has never worked as Deputy Commissioner at Visakhapatnam during his lifetime. But what has happened is, I have filed an application under section 24 for transfer before the Supreme Court. In the Supreme Court, it is alleged that I have stated that the complaint is also staying in Visakhapatnam. So, the complaint petition, I have pointed out the paragraph where the complaint petition itself, wherein it stated that he appeared in the Supreme Court also and opposed, and in spite of that, this order was passed. Magistrate, he files, after the case is disposed of, he files a complaint before the STM Bhubaneswar, saying that wrong affidavit filed in Delhi, in Supreme Court. And the court, by order dated 4/12/2015, at page 21, you will also get it, took cognizance of offence under section 199, 200, 420 IPC. So my point before your lordship is, there is a clear prohibition for the magistrate to take cognizance in view of section 195 of CRPC. 195 says that no court shall take cognizance in the following cases where and procedure has been laid down. And 340 is the next provision by which the you should have proceeded against you in 340 before Concerned Court, not here. Yes, that's all the point. Therefore, cognizance, taking of cognizance by the what happened to your marriage, by the way? Almost broken. Almost broken. But then for some time they are living together and then again getting separated, assaulting these. What do you say? Yes. Why unnecessary prosecuting all this? 2013, some affidavit was filed in Supreme Court, you contested, transfer petition was allowed, and you should have filed a 340 application. The lordship, after the petition was transferred to the Visakhapatnam family judge, London court, thereafter they have filed a petition for procuring the salary details of the parties. That is where it has been categorically stated that he is working in Bhubaneswar. And the salary details of the opposite party was procured for the marriage. Do you have any such? The petition which was filed and it was subsequently transferred to Visakhapatnam, it was dismissed as the OP could not travel to Visakhapatnam and all. Currently they are living separately. Why would you settle? What will you get out of it? Lordship, we have tried. That is the reason we have filed a divorce petition in Bhubaneswar, London Court, Bhubaneswar, under section 13(1). What that is going on? No, that was tested and it was dismissed in the Visakhapatnam. And thereafter what happened? Thereafter you filed appeal against that? No, your lordship. Well, only thing he is sincerely doing is coming to house and I will have to quash it. Yes. Lordship, I'll tell you why. There is simple reason. I am not going to all this thing. A wrong statement is made by them. Yes, sir. And Supreme Court has acted upon that. If I say that the offence is made out, I am going against the order by which the case is transferred. So therefore I can't entertain this. I have to pass it. The trial court is absolutely wrong. So should we have filed a counter? Then eventually what you are saying? The Supreme Court was wrong.
Eventually what you are saying, Supreme Court is wrong.
Right.
But wrong or right, Supreme Court has taken cognizance of the fact that you are staying in Visakhapatnam. Therefore it was transferred. Staying in wherever, the wrong statement in an affidavit is relied upon by the court, the apex court of the country, and a order was passed. How the trial court can go into it, whether it is wrong or right?
Possible false evidence was being filed. Lordship.
Where? Then the trial in Supreme Court.
Yes, sir.
But the Supreme Court is not saying it is false or whatever.
Yes, sir.
Rather, Supreme Court is acted upon that.
The reason.
Statement and transfer it.
Yes, sir. The reason being
What I say is that if Supreme Court will say that is wrong statement, then eventually you are doubting the order of the Supreme Court. We can't do that.
And there is a clear prohibition also.
You either you settle or I'll quash it.
There is possibility of settlement.
I'll quash it. Okay.
Okay. The date may be given. We will try to settle in between.
There is no possibility, my lord, because I have, you will also see from the records, at one stage I have stated that they are staying together. This honorable court wanted an affidavit to be filed. When I asked her to come and file an affidavit, she has shown the photo assaulted. And they are virtually staying in one, not staying in one roof, and they are separate.
But in the same time, the divorce is not granted.
That is all right. But whatever will be the fate of the case, that will be different. But here a criminal case, I am.
But why didn't you engage this proceeding and try to settle?
I encourage that, but then they should beat and do it. Ultimately,
where are you staying? In Bhubaneswar. You are there in Bhubaneswar. I'll send it to High Court Mediation Center.
That was earlier, such a direction was there. Nobody came.
No direction was there. In this, no, your lordship. In this matter, no direction.
There was a direction that it should go to mediation.
On the consent and the consent of both the parties, I am sending it. And I'll quash it. I am making clear. I am giving one opportunity.
Yes, sir.
I'll quash it immediately.
Yes, sir.
And if you don't appear there also, okay. I'm just giving one opportunity. The idea is
right. Ultimately, it was
settled. Why not? Why not? The petitioner is accused in what is 1cc case number
2013
4064 of 4. What is that? 1cc case number 4064 of 2013. The opposite party has initiated the proceeding against the petitioner on the allegation that the petitioner has had given wrong affidavit before the Honorable Supreme Court in the transfer petition filed by her in the year 2013. The transfer petition filed by the opposite party before the Honorable Supreme Court. Where is that?
The petitioner
being PP number
218 of 2013.
218. Transfer petition civil number 218 of 2013. Was allowed by the Honorable Supreme Court and the pending divorce petition from Visakhapatnam to Bhubaneswar Court. Bhubaneswar Court. And eventually the divorce petition was dismissed. And it was not taken up further. The entire evidence in the complaint reveals that the petitioner has some declaration of fact before the Honorable Supreme Court. Be that as it may, since the transfer petition was a contesting petition and the Honorable Supreme Court has been pleased to allow the transfer petition, it is not open for the trial court to go into the veracity of the affidavit which was filed before the Honorable Supreme Court. Honorable Supreme Court. Honorable Supreme Court. At this stage, the counsel for the opposite party from the court agrees that they will make an effort to settle the dispute. Therefore, on consent term, the parties are relegated to the High Court Mediation Center for exploring the possibility of a settlement. The coordinator of the mediation center is directed to fix a date for hearing and intimate the same to the parties, and it will make clear the opposite party will not cooperate. Then the present matter will be cooperate in the mediation process. The present matter shall be heard on the next date of hearing. Awaiting the mediation report list on the last day after vacation, October. It's in first week of November. 4th of November. Yes.
73.
Publish.
Kindly.
Application. Okay.
Plans to the order dated 22 December 2016.
22?
By IC we are sure.
Oh, this is the okay.
Now they are not paying the interest till today. Only after the intervention of this one.
See, this is pending since 2016.
I have no contact with petitioner. That's why I'm facing.
Then I'll dismiss. it. I don't. The present matter is arising out of maintenance petition. Maintenance. What was it? What was challenge? 6. The petitioner is seeking quashing of the order dated 7/5/2016, whereby the family judge Katak had directed the petitioner to pay rupees 3,000 per month. 3,000 per month as a maintenance. The present petition is pending since 2016, and interim order dated 21/12/2016, directing the petitioner to pay the maintenance amount has been although operating, but the petitioner has not paid the maintenance to the opposite party. There is a huge areas to be recovered from the petitioner. Then consequently, the petitioner submits that he has no instruction from the petitioner. In view of the aforementioned, I am not inclined to entertain this petition. Accordingly, the petition is dismissed. Yes.
74.
All the areas I will find the proper application before the court.
Who stopped you? Do it. You can do it. Yes. Yes.
This arises out of a proceeding under section 138 of the NI Act.
Yes.
But I have read for quashing of the proceeding mainly on 2 grounds. I'll just take your lordship's kind attention first to page 12. Well, their complaint petition.
Yes.
The lordship will find page 12, annexure 2 series.
Yes.
The lordship will find number 1, check number so and so, or amount of so and so, that was drawn on 2/3/2006. Now they presented the check much prior to that date. 14/2/2006, it was returned by the bank.
Show the bank memo.
Bank memo I am showing.
Yes.
Annexure 2. Then your lordship may kindly come to page 13. That is the check. Certified copy of the check, my lord. This is 2/3/2006.
Not 138. In the case of 420, not 138.
Against whom?
Against you.
How?
You gave a check up to the March and February you closed the account.
No. It's no
See the memo.
No question.
See the memo.
What has happened, my lord? The petitioner has closed its business since.
Whatever. You have given a check of.
These are the checks which were given for the purpose of security, my lord. Those have been utilized by them for the purpose of banking, my lord.
2006 is the check. Now he deposited beforehand. It's not permissible. Okay.
Not permissible.
And what is the reason of dishonor justice? Account closed.
Yes.
On 6/2/2006.
No, that is because I have closed my business much prior to that, my lord.
Business is something different. You have given a check, then
2000 business has been closed, my lord. And thereafter, subsequently we closed the account, my lord.
So the reply to the notice.
No, reply दिया है Now, if your lordship will
so otherwise the presumption operative. These are
presumption केमती आसिबो proceeding टा जे ହେଲା your lordship will kindly turn to the notice, demand notice.
Why have you not given reply? Reply to the notice. That is the statutory requirement.
Therefore, proceeding
then you have to face it.
Ingredients are not satisfied. That cannot be.
Then maybe what you should have replied.
Your lordship says, my lord, that there may be a different.
Show me a judgment without.
Your lordship.
Show me a single judgment. If you have not.
So your
I must be right now to be slow.
If your lordship, I'll get the point more. That is the one, the first point. Second point, your lordship may kindly turn to annexure page 17. 17, the demand notice.
Yes.
This demand notice was issued. There are also same dates have been quoted. And this notice was served on me on 10/4/2006. Admitted. That is the certificate copy I am having. Page 22, your lordship may kindly. Prior to completion of 15 days.
All these things you should have said in the reply.
No, reply point. If that case, वो 15 दिन भीतर वो पैसा दे ही था कि कौन करता है, that is a different issue altogether. But on
when have you received?
I received on 10/2006, and for 10/4/2006.
Show me the complaint. What is the what they are saying regarding complaint.
Page
10. Yes.
Paragraph 6. They have said that the notice last chapter line, the notice said UPC is deemed to have been received by the accused so-and-so, and the notice said through registered AB is also received by all the accused persons on 10/4/2006. So now
limitation.
And they have filed the complaint petition on 24/4/2006. Your lordship will get it at page 11.
Can you have a case? Sir, issue notice to opposite party number.
The notice is issued. They have already appeared.
Where is he?
I do not know. He was appearing earlier, but
notice issued?
Yes, notice has been issued. There has been stay of further proceeding.
Where yet to that. None fees for opposite party number 2. Release the matters of the interim order to continue. Yes. You have a case because see you can get over that non-filing a non-replying. Because prior to the limitation period he is filing.
Presentation of check prior to the date.
That is that.
138 says from the date of issue within 6 months.
He should have filed a 420 case also.
But
138 you have. Yes. Next.
75.
Interim order to continue. Yes.
May it please, your lordship. My lord, item 70. My lord, may it please. My lord, item 75. The both the petitioners are accused on a protest petition. The petitioner number 2 is deceased now. So against him the case may be abated.
Okay.
My lord, the case.
And one?
My lord, one is there. I require some time. Let it come after vacation.
Next mission and counsel for the petitioner submits that petitioner number 2 in the present case has expired Therefore, the present petition qua the petition number 2 stands debated. It's the matter for hearing on the next yes.
My lord. The interim order may continue, your lordship.
It's made clear that no further adjournment shall be granted in
Yes,
this
your
matter.
lordship. Yes.
As the hearing matter is pending since 2016 and interim order is operating since then. Yes.
My lord.
Yes, Mr. Mishra.
My lord, your lordship, the petitioner before lordship for filed the application for quashing of the proceeding as he has been allegedly made an accused for receiver of the stolen property under section 412. Only I conflict with this thing, my lord. What happens in this case? A truck was stolen, subsequently driver was murdered, and matter was transported to Calcutta, and the petitioner being the one of the student engineering works alleged to have received the stolen aluminum coils. Here, I will put 3 points before lord's consideration. The case is solely based on a confessional statement. Even when not assume for the sake of document, but not considering, there is no seizure was effected. No the call record is available. Only after 2 years, one accused who was the prime conspirator of the alleged stealing of the truck and all that, he confessed before the police that we have disposed of the materials at the premises of the petitioner. So my humble submission in this case, except the confession statement, as law laid down by the Apex Court as well as yes, their confession statement is weak piece of evidence, except that no incriminating material of the mention of 114 of Evidence Act also is not established.
What happened to the trial for the other accused persons?
That is there. I have the charge sheet copy that is pending for the SDGL, that is still pending. Because many other accused persons are there, some other are pending, some other were there, but only have added after 2 years, only basically one piece of evidence that you have shown at 319. No. I will charge it. Yes. That much I will for quashing because I am a businessman. I am stationed at Calcutta. I have nothing to do with Dokaiti and stolen. Even the allegation is not without established. Only the confession statement. Having been quantitative records, having been in the seizure. So by the I will read
anything recovered from him?
Nothing recovered.
Anything recovered? Even if you bring 27, unless you recovered nothing, 27 will not operate. Huh? Okay, it's not. Let him see. And when we status up to the trial, insofar as the other co-accused. Mr. Lalit Misra, Land Counsel for the petitioner submits that there is a stay operating qua the stay of the trial court proceeding operating in favor of the petitioner. However, there are many other accused persons, those who are co-accused persons, those who are taking trial in the present case. He seeks an adjournment to get the instruction regarding the status of the trial insofar as the co-accused persons are concerned, least the matters also. Yes. Continue. Yes. Ask you. He's waiting. Yes.
Watching the FIR,
yes.
Application, license holder to deal with Panmasla and coin. But they on the basis of the FIR logged by the ASI, they have told me indicating that it is adulterated. Accordingly, they have filed the case on section 272, 273, 124B, 34 IPC, and 220. Yes. No, there is an order with that effect. This will kindly see the order 17/4/2019. Kindly see the order.
17/4/2019. 19. Yes. Yes.
Yes. The IO is present in court who submit that he has taken over the charge of the case yesterday. It was submitted by Land Counsel for the petitioner that despite personal appearance and submission of the documents by the petitioner before the earlier investor is not taken in consideration. The petitioner license holder in respect of the alleged property for selling purpose. Considering the submissions, it is directed that petitioner person shall appear before the investor on 3/5/2019 along with the documents. We shall be examined by the imbue officer and the finding thereon be reported in the what happened? Well, that is when although I appeared and submitted my document, there is no reaction till no reaction.
No, nothing is filed.
No, they let him say that.
Yes.
Nothing, I have appeared and filed with the state document.
And there is no stay operating.
Yes, ma'am.
Why will you not file charge sheet?
No, that is a stay, there is no court.
Course election doesn't mean that stay of investigation.
In spite of my submission of document, they have not taken any action.
Yes.
Too much an old matter, my lord. In between that, my lord, file has been lost.
Sir, my daughter dated 17/4/2019, this court, has been, when the matter was taken up on 17/4/2019, the following order was passed, considering sufficiency for. Then counsel for the petitioner submits that pursuant to the aforesaid mentioned order, the petitioner, the petitioner had appeared before the investigating officer and submitted all the possible documents. However, till date, no action has been taken on the and charge sheet has not yet been filed. Mr. Rahul, counsel for the state, seeks an adjournment to ascertain regarding the status of the present case, release the matter form. Okay. And interim order to continue immediately after it. Yes.
78. This is a case matter to quash the cognizance in the complaint case, which has been filed to ground the property by abusing the process of law matters. The offense is, my lords, the section 453, 440, 294, 506, 395.
Yes.
Your lords, can you see the concept of the complaint petition, my lords? That is page 43, my lords.
Yes.
Para page 43, para 2, my lords.
Yes.
Married, my lords.
43.
Yes, my lords.
Yes,
Page
para.
43, para 2, my lords.
Yes.
Late Agarwal, the deceased father of the complainant, along with his other brothers, namely Lord late Maman Chand Agrawal and late Bhagat Ram Agrawal, late Mahavir Prasad Agrawal and Mandal Lal Agrawal, had purchased the plot number 240 measuring an area of 1 acre 40 decimals appertaining to Khata number 73 of Moujal Chatuangko on 19/4/1965 on the strength of registered sale deed bearing number 1149 of 1965 and were in possession of the said lands. They have constructed a boundary wall around their purchased lands and had also constructed some pakkara roads. After their death, the complainants being the heir and successor of his father, late Dhanapati Agrawal, and his father, namely Talchand Agrawal, Sushil Agrawal, had been possessing the land and the building standing there.
Yes, come to para 3.
My lords,
Para 3 is the offense.
Yes, ma'am. That on 2/7/1960 at 8 a.m.
Para 3 and 4 is the offense.
Yes, ma'am.
Not 3.
Coming to me.
Yes.
Apparently that on para 2, ma'am.
Yes, I read it. You tell me now.
Then your lordship may come to page 38, my lords.
30?
That is the order under section 23A of OLR Act passed by the sub-collector delivering the possession of the lands in favor of the present petition.
That's not the issue. Issue is, see, you have scolded them, forcibly discharged you off,
my lord,
and they bring their offense.
My lord, once he is not in possession of the lands and I am in possession of the lands, the story that he has come that I have gone to them is a false one. He is a trespasser to my land.
Things can be determined in the trial only. The cognizance says, how do you expect me to read all these things and find out?
Once the land doesn't belong to him and he is not in possession, my lord, the question of my trespassing or entering into the land doesn't arise, my lord.
See the utterances you have made in the complaint itself, it is written.
It is my land. The entire, when the root of the case is false, the entire case will false, my lords. Your lordship can see, my lords, I will rely upon the Meghalaya.
Can I go into the root of the case in this case,
my lords,
on the basis of document which you are relying upon?
My lords, one thing, my lords, he is not in possession. He says that he is in possession, but I am in possession. When I am in possession of the land, prior to this occurrence, the land was delivered in my favor. My lords, the occurrence season, valid occurrence season 2/7/2016, and the land was delivered to me, my lords, prior to that on 21/5/2016, my lords. The rate of delivery, my lords. Once the land has been delivered to me, my lords, the entire allegation of the offense is my fault. Entire allegation, my lords, land doesn't belong to me, and so that he is in possession of the lands. and I have entered into in his position.
Yes.
Entirely case is false, my lord.
Anything else?
My lords, I rely upon the judgment of the my lords, the Megamala case, that once the case is not properly repaired with substance of facts, it amounts to fraud, my lords. Once the fraud is there, he cannot get any look.
The moment you say these are facts, it has to be ascertained.
My lords, once the my lords, fact means,
And see the cognizance order.
my lords,
Come to the cognizance order.
one, you will not seek the yes, my lords, the cognizance, my lords, once somebody will come to the court and say he has an land, but he was not in position of the land. Land was in my position. I was in position of the land, my lords. That is my lords, case 38, my lords. Your lords, can you see the page 38? Examine the case, it is found in the
Meaning that the complainant came to the court,
yes, my lord.
filed a complaint,
Yes, my lord.
and made statement on oath.
Yes,
On that basis, a case is made out.
Yes.
Cognizance is taken.
my lords, he says that he was in position.
And if he has taken, if he has made false allegation and all, it will be ascertained. You prosecute him, Malici is prosecuted.
My lords, my lords, court and say something, but if it is not a fact, my lords, how the cognizance can?
That has to be determined by the trial whether it is fact or not.
That is a matter of record, my lords. That is a matter of record, my
At
lords.
this stage, I don't think at this stage I can go.
The brother is 38, my lords. And the delivery was given in my lords, page 41, lords. Your lords, you can see. The possible contaminant, whereas the land described in the civil below has been put into position of Girirai. That is the position of which the accused in the complaint case.
Yes.
The land has been given in the position, my lords, but he was not in position of the lands. But on the date of Alice occurrence, I was in position of the lands. He says that I entered into the land, but it is the first one. The moment land belongs to me and I am in position of the lands, then
What will I do to the 202 statements?
my lords, somebody will come to the court and say false things, my lords. Anybody can come in that same case, my lords.
That's what I'm saying, sir. 200 complaint, followed by inquiry under 202.
My lords,
Statement has come on record. On that basis, cognizance court has taken cognizance.
but the matter
If it is wrong or right, it is not the business of the cognizance court to look into it. in this case.
I will rely upon my lords the judgment of the.
You show me any judgment where at this stage I can go into the whether the statement made what you call the complaint is wrong or right.
Your lords,
Stage of cognizance.
your lords, can you see the seafood limited matters? First case, I have
Seafood I know.
yes, my lords, see the para 27 matters.
Seafood will not help you.
Another case we had, Madhav Rao, Jiaji Rao, Sindhya matters. That is, my lords. Let's see, my lords, the para 23, the 27, and this, my lord, Madhav Rao, Jiaji Rao, my lords, para 7, my lords. It is for the court to take into consideration any special fee which appears in a particular case.
Only thing it says that you apply to mind. See the cognizance. Therefore, I'm saying mind need the cognizance.
Once,
And he has said that 200 statement of the complaint and the inquiry followed by the inquiry under 202. I am satisfied that prima facie case is made out. Therefore, I am taking cognizance.
but my lord,
This is enough.
by that time, he was not in position. Once the matter comes out that he was not in position, my lord, the entire case is false, my lord. He says the London magistrate says that he was in position. But by that time, so in position, my lord, in a order under section 23A, OLR Act, the delivery position was given to me. That is
For the time being, you forget about the position. Para 4 of the complaint, you just 3 and 4, you read it.
yes, ma'am.
You went inside and you see the utterances.
He was not.
He was scolded.
He was not in position. One thing, my lord, first thing, my lord, he was in position when he has came.
Suppose he has come forcefully to your
Yes,
side.
my lord.
Suppose.
Yes, my lord.
Can you scold him? You say that I have a pistol, I'll fire you and eliminate you and all these things are there.
Once the matter, my lord, your lordship can rely upon that.
Okay, I'll pass the order you to give that.
I will file one written note, my lord.
Sorry, sir?
Written note, my lord.
Yeah, definitely.
My lord.
Yes, definitely. Then counsel for the petitioner has judgment reserved, or then counsel for the petitioner seeks 1 week time to file a written note of submission along with relied upon judgment. Relied upon judgment. He may do so within a week. Judgment, yes. My lord, you give the judgment and the part of the judgment which you are relying upon, including Pepsi. I mean,
May I pay my lords that little
more time?
little more time, my lords.
Okay, little bit 2 weeks.
2 weeks, my lords. Let it be maybe 4th of November.
What? Okay. Okay. Yes, 4th. Yes. By 4th November. Yes. Well, please, sir.
Lord, I have challenged the affair in the entire thing before this criminal code, primarily on the ground that COW Act as a application of the instant case when the proceeding is going on. Because now the affair has been registered. Annexure 2 is the affair.
Yes.
Annexure 2 was simple allegation that the present petitioner happens to be a builder. One of the partners of the firm.
EOW cell, huh?
Right.
Yes.
But the simple allegation page 32 that have received 4 lakhs of rupees since April 2012. Page 32.
Page 32. Yes, I'm there.
And more than 3 years have passed, but not been made. No apartment has been allotted in his favor. But he lost this affair, which was
you are the builder.
I am the builder.
You have taken money, why don't you give him?
It has already been given more than that. If you also can see Annex 7.
7.
Yes. My lord, this matter brings to the OPID, my lord. No, just a minute, sir.
7.
Annex 7, my lord.
Yes.
Page 68.
Yes, I'm there.
He is one of the party here and the informant.
Okay.
He says, I am the petitioner in the criminal case. It has been registered as a case. I have been appointed for the expert only for 3 BHK under Restraint Power
project.
So Mr. Prabhat Kumar Nanda is unable to hand over the flat.
Prabhat Kumar Nanda is unable to.
In the confidence of the well-wishers of both parties, the matter arrived at amicable settlement. As per the amicable settlement, I have received 9,82,000. My clear principal with interest up to date.
This is one. What about the other investors?
Sir,
in the Prestige project.
Sir, EOW case doesn't come. They have not lost an affair. They are not they never filed any affair at any point of time. Actually,
Prestige project stands in the land.
IO has tried to bring those persons within the ambit of investigation, saying that it comes from the EOW Act.
OPID Act, therefore.
When EOW Act doesn't have any application yet. But if I have given that annexure 9, if you page 73.
73.
Page 73.
Yes. Yes.
That EOW circular. I got that. Page 73.
Threshold. 1 crore threshold.
Yes. Next page. At page 74, in pursuance of Home Department resolution.
Clarify the job.
Related fraud investigation. Money circulation fraud involving more than 20 investigated by you.
Who is getting for OPID? See,
and sir, the law that has been amended, it says it doesn't come into the purview of this.
And you are covered by that judgment also, Rashmi Khotia.
Yes. The 2 judgments are there.
Judgment covered by Rashmi Khotia judgment. And the circular says that minimum 20%
Right.
he should cheating with minimum 20%. Threshold is 1 crore. And is 4 lakh rupees he has taken. 9 lakh rupees he has paid. 9 lakh rupees he has paid and affidavit is there on record.
Right.
How to do it?
The case actually doesn't come in that.
Let it be done tomorrow, day after. Let it be done. You just your breathing council will intimate him tomorrow. Oh, spill over to tomorrow.
Monday.
Monday. Sorry, working Saturday. Monday? Monday. Okay. Monday. None appears for partly heard. Partly heard. Huh? None appears for opposite party. Least met Monday. Entry was date. Yes. Yes. Entry order is entry order continue. Item 80. Yes. Yes, sir.
On behalf of the opposition party, there is Orissa State Civil Supplies Corporation.
Yes. What do you want?
Lordship, I am acting for the petition. Lordship, this is a civil nature who are challenging consolidated 8/5/2018.
Yes.
Passed by the subdivisional judicial magistrate Bhadrak. The matter, the crux of the case is that the petitioner came with an agreement, entered into an agreement with the opposite parties for delivering of the rice for 10 years. And thereafter, he was to deliver an amount of 44,911.
Yes.
To that, he could not deliver an amount of 36,295, leaving him a differential amount of 8,515, which was sum up to 1 crore. Like what? Who are you? And the petitioner was entered into an agreement with the opposite parties for delivering of such rice. And the director of the company,
Ganpati Parvoli. Yes.
Miller.
Cognizance is taken 409.
Yes, Your Lordship. Thereafter, we have paid all the differential amount, including the final settlement amount, such as in Annexure 4 and Annexure 6 of the petition, Your Lordship.
What is the total amount? 1 crore 22 lakhs.
29,130.
Yes. How much you have paid?
1 crore 22 lakhs we have already paid. Thereafter, we ended for final settlement of 5,72,721.
That also you paid?
Yes, Your Lordship. That was also paid by us.
If you were not satisfied,
Yes, they have already paid all the amounts.
then what?
Instructions also says.
Then what else? Well, we 409 interception and he has paid. Technical some offense might have taken place, but the fact remains he has paid. Why unnecessary?
Yes, okay. That is also
And the opposite party also says, you also say,
but that is
instruction. Give me the instruction, I'll cause it. Total amount is paid. This is 5 lakhs. What is this amount?
that is the penalty.
That is
That was the final settlement amount claimed by the opposite party.
in the audit the letter part that is written in the audit.
You are appearing for opposite party number 2. 2.
And opposite.
Who is the informant?
Madam?
Informant. Who is the informant?
Improvement is opposite party number 3.
Who is appearing for 3?
He is the subordinate officer of the opposite party number 2.
Okay. You have no problem.
No, I have no.
He doesn't have problem. Petitioner is accused on so and so case. Allegation against the petitioner is so and so. While the order dated 8/5/2018, the SDGM Bhadrak has taken cognizance of offense under only 409.
Yes, Lord.
409 IPC in GR case number 1503 of 2017. It is an admitted case on record that where is that letter? Admitted case on record that the present petitioner, who is you are the director, one of the directors.
Yes, Your Lordship.
One of the directors of Ganpati Bar Boiling in India Private Limited has made good the entire entrusted amount of rupees 1 crore 22 29 133. This is reflecting from the annexure 3. Annexure 3. subsequent thereto, the petitioner company, the petition, I think parboiling, what is that parboiling? So and so, through the present petitioner, have also made good to the entire due amount remaining due with the penalty of rupees 572,721. Okay. The same thing it has been endorsed by the opposite party number 2 by the letter dated in a letter issued to the present petitioners on 6/7/2018, which is part of the annexure 3 to this petition. The State Council has also obtained instruction from the instruction from that's from the UW on 25/4/2024. The instruction reads as under. Let me go to appealing for the opposite party number 2, who is the informant. Opposite party number 2 and 3, who is the informant in the present case.
The informant is actually the general manager of the department. He is not a party in this case.
Informant is not a party. How can it be passed without informant? You implement
Which is the party, my lords?
who?
Party. Odisha State Civil.
He says somebody else. Where is the FIR?
FIR is lodged by the general manager, procurer, Odisha State Civil Service Corporation Limited.
General manager.
Yes.
Secretary General.
No, he is not.
Yes, general manager.
District manager.
Kishore Chandra Das, procurement manager. What do you mean?
Perhaps he has wrong written district manager.
He is the district manager.
Yes, he is the
Who is not? Opposite party number 2 and 3. Also, apportionment fact.
General manager.
On the Mr. Rajgaria, current counsel for the petitioner, submits that since the entire entrusted amount along with the penalty has already been deposited, no case is made out against her. At this stage, it is discovered that the informant in the present case, the general manager, procurement of State Civil Service Corporation
Supplies.
has not been implemented as a respondent in the present case. I am afraid, in the absence of the informant in the present case, the FIR could be passed or not. Therefore, the petitioner is given an opportunity to include the informant in the present case. Due to the course of the day and the case of the day, and issue notice to the informant, returnable within so and so. Meanwhile, the proceeding before the so and so is stayed.
He has appeared to.
He has appeared for the 2 respondents, those who have nothing to do with this case. If the informant is someone, you are including someone else, what to do? Same department, but same department.
Sir, or general management confusion हो गया.
Confused, we are also getting confused now. Yes. Miss it, you which application. How the process? Tomorrow? Yes. 81.
Facts are petitioner.
You are for?
Well, I am for the petitioner.
Yes.
Well, one is proceeding.
Special manager, messenger, service complete?
Yes, my
Yes, sir.
125 was instituted against the present by the wife against the present petitioner. On 30th of April 2015, the learned court directed payment of 15,000 to the wife, 5,000 which should be his son and the daughter. But the wife challenged that order before this honorable court in 30th.
You simply say that divorce has already been granted, 17 lakhs alimony I have paid, so she is not entitled to maintenance.
I have deposited the question that
Yes.
in appeal, my senior and I both are appealing, wherein there is a order transfer on that my learned senior doesn't challenge the divorce, only challenges the quantum, which is not in dispute. If your lordship wants, I can produce that.
Yes.
Now the
Quantum is satisfied now.
quantum
is not satisfied.
Only challenge the quantum. So let's just
To say that the divorce is now absolute.
absolutely.
If the appeal is pending, how is the court can take it?
It has been recorded by
Show me that.
then I have to download that copy and give it, because now
Malas, I agree to that. But 125 also includes a divorced wife. That is what the learned trial court order says. That she is not divorced. Balance, his main case is that 17 lakhs, whatever was awarded by the trial court, I have deposited. Now, we have come up in appeal, 17 lakhs is too less. This should be the amount the court fixes. Now, till the date the final amount is adjudicated, my lords, my case is that I should be paid my maintenance till that date. After final amount is, I'm just stating my case.
this case which I want to
Just have a glance at the impugned order.
Are you paying surrender?
Yes, son and majority, so it was stopped. Doctor is up to date. Only question is whether my appeal get it. In this application, which is pending in appeal, I have also challenged 17 lakhs. My grand senior has also challenged.
Quantum has been decided there. Yes.
Now, they are considered in the board in the argument, and it is noted in the order that they don't challenge the decree of the board. Her status as wife ceases. Only question is permanent alimentation. This is my way of interpretation, subject to what your lordship is. What happened? Till that I am paying to the law.
Where is the degree of divorce?
There is no decree.
Yes, yes, it is annexed.
There is no decree of divorce.
It is annexed. There 17 lakhs was directed to be paid, and decree of divorce was done. Paid 46.
But this degree is already drawn. Degree is drawn. Degree is already under question. Unless the appeal is disposed of, the degree will not attain final. It has to culminate into a degree final degree.
That they won't challenge the decree of divorce.
Yes.
If you are not sure, confirm.
And they done in the international during the appeal. What will you say? Whether she is legally wedded or not?
She is now they're confident that.
What will be her status?
She is now divorced wife. She is now a divorced wife. Because they are considering before the court that we don't challenge the decree of divorce. We only challenge the quantum.
She seems to be your wife now. So no question of maintenance.
Yes, but 125 says, wife includes a woman who has been divorced by or has obtained a divorce from a husband and is not remarried. But they are not remarried, they are not.
No, she is maintenance 125 or
125.
Consider for the moment that she is a divorced lady.
Which a fresh cause of action.
Yes.
Well, it's still date the decree of divorce has not attained its final.
There is a dichotomy now. He says there is a fresh cause of action. But you attained a different status today. When you filed 125, that time you are legally wedded wife. The moment you can then your status will change to legally wedded wife to a divorcee. Then the cause of action, fresh cause of action arises, so you have to file a fresh petition of 125.
This has been dealt with by the trial court itself.
Show me that.
Page 10.
Yes. 10 of the judgment.
Petition running page 4.
Yes.
The first and foremost,
Yes.
the first and foremost question is to be answered
Yes.
whether one application is sufficient for future claims regarding realization of maintenance. It is to be answered that one application is sufficient for future claims after so long it is pending. Month to month, fresh application for recovery is not required, nor any amendment is required to be made every time. It is enough if claimant informs court that amount during pendency is not paid. One and same application can continue for recovery or future maintenance also.
Then that point is taken care of.
The now status that now she's a divorce wife. This similar mistakes which was
No, see the judgment of this court on the Supreme Court says that if the status changes, the cause of action continues.
And this order first, this order which is impugned before your lordship. If an order for maintenance is made by a magistrate, its effect and enforceability can only be stopped by another statutory order until then such order is executable. In the present case, the petition dated 18/4/23 is filed by the petitioner wife claiming for realization of another period of maintenance. So on that ground, the petition cannot be thrown from the file. So far as the payment of permanent alimony is concerned, it is admitted that the opposite party husband has already deposited an amount of rupees 17 lakhs in view of direction in the decree of divorce passed by the Learned Family Court, Bhubaneswar. The opposite party husband resisted the order of this court dated 21/6 directing him to make payment of the arrear dues as per application dated 18/4/23 on the score of payment of permanent alimony to the petitioner wife, and the son became major. Admittedly, as per provisions of section 125 of CRPC, major son is not entitled to receive father maintenance from the father, and the same is also admitted by the petitioner wife.
Next.
For the wife includes divorced wife, and subsection 4 of section 125 is not a bar for the petitioner wife claiming maintenance for herself as long as she is not remarried. During course of hearing, learned
yes, Madam, I know this too. Question is, this execution arises after she was not divorced. Now the status is a divorce wife. She can file fresh application 125.
See, cause of action continues till she remarries.
No.
That is 125.
She has got a divorce. That is the view of the understanding. So, and judgment of the
for the wife includes divorced wife and subsection 4.
By the way, what are you doing?
These are exception.
Now I'm jobless. I'm jobless. I'm not.
Lordship, that's not valid. Your lordship should go through this order. Not just placing the order, thereafter your lordship goes into the judgments.
Yes.
My lords, further, page 11, further, wife includes, your lordship gets it?
Yes,
Wife includes divorced wife, and subsection 4 of section 125 is not a bar maintenance for herself as she is not remarried. During course of hearing, learned amicus curiae for the petitioner wife brought to the notice to the order of the Honorable Supreme Court in the case of Tarun Pandit versus State of UP and another in criminal revision such and such, in which the Honorable Apex Court, taking into consideration of issue of overlapping jurisdiction enumerated in the case of Rajneesh versus Neha, in grant of maintenance held that a wife can for maintenance under different status. And there is no
They say that he's taking classes and luxury
protection of women under Against Domestic Violence Act and 125 of CRPC under Hindu Marriage Act. It is also noted that the opposite party mentioned that the petitioner is an educated lady, BA MAd, and works as a teacher and attending private coaching classes and enjoying luxurious lifestyle. It is also to be noted here that this court in dealing with the petition for realization of arrear maintenance is an executing proceeding. In an executing proceeding, it is common that in an executing proceeding, court will execute the order passed by the court in a maintenance proceeding. The OP husband has not attempted to vary or modify or alter the maintenance amount ordered in CRP of 2013 in terms of section 127 of CRPC, showing the cause of non-payment of permanent alimony to the petitioner wife, for which this court, while dealing the execution proceeding, has no authority to stop the realization of arrear maintenance of the wife and minor daughter. That both parties admitted that the order passed by the Honorable High Court. So, that order has not been varied. Under 127, if it has not been varied, then it is an executing decide as per the order which has been affirmed till the Supreme Court.
125 court is an executing court.
Executing court, the order has not been varied. What we say, it includes a divorced wife until she remarries.
Why not to file 127?
I'm telling you, when she filed this execution, she suppressed the fact that the 17 lakhs has been deposited in the court.
No, that will be to court record.
Yes. She suppressed, got an order expired without issuing a notice. I approached this honorable court in a criminal division. This honorable court asked the proceeding directly to consider that 17 lakhs has been paid.
Right.
He says 17 lakhs has been paid. After the date of decree of divorce, not a single rupee is due. After the date of decree of divorce, daughter and
Insofar as he sees written how much? What is the arrear?
122. Question is whether wife will get it from in the present status when the ticket. Somebody will talk to
This time you should not get accepted. Now right now I am telling you now.
Whether we get decree of any areas. 125 will be accepted. Yes, I do not dispute the fact that a divorced wife is not entitled to maintenance. She has to file a fresh application. And I can.
Fresh application is taken care of. The cause of action continues. Since he remarries. That is there. That show me whether cause of action ceases when divorce is granted. Then in that case,
But I will be going to 127 code.
Who says that?
No, it will be treated as 25-2. It will be treated as 25-2, not 125. I know even the matrimonial couple, they will file an application for maintenance. Why they are not proceeding in that matter? They can easily get maintenance in matrimonial couple. There are no application. I have given it an affidavit. They are moving an application in matrimonial couple to get maintenance.
That is pending. Where is that application? Where is that application? If there is an order application, you yourself be satisfied that this order is application.
This was at the earlier stage when they were not paying the maintenance. That is why this order was directed. Your lecture shall see this order.
So this plays all these things and makes very
this honorable court directed that if he doesn't, it is clear.
I can demonstrate what is in play.
We will scrap the right of audience if he doesn't pay the maintenance. Because I had asked the maintenance.
Call for it, reopening the first, the second, call for that proceeding. Well, it's like the problem is the law is tilted towards either side.
Yes.
That's the whole difficulty. No, why can't you pay 50% and finish it up?
It's a cardiac surgeon.
I have read the impute order, it says that both of you are leading luxury life. That's what the finding them.
I don't know what he thinks so. I don't know. I've seen the number of cases he has on board.
I think both of your friends are leading luxury life because they can afford both of you.
Senior counsel. When the wife chooses my senior Mr. Kanamor.
Luxury is apparent. Okay, I'll see. Thank you. Yes, thank you. All right. Monday. 100.